Lordship. But I take mention item number 7 of today's daily list, my lord. My lord, kindly pass over for the day, my lord. I have taken
There is a
consent-
IA.
My lord,
There is a IA bail
my lord,
application.
my lord,
Why you want these matters to be passed over?
my lord, I'm not prepared, my lord. The matter is also
No,
take
this is-
item number 6, my lord. My lord, for the day,
We
my
don't
lord.
appreciate this. These applications for bail are inherently urgent matters. Good. Asking for adjournment, I am not prepared. My mood is not good.
No,
These
no,
are
my
the almost the grounds. Huh? This is not the way.
My lord.
We'll grant you adjournment, but they are very unhappy with these adjournments. On the prayer of Mr. DJ Haloi, learned counsel for the applicant, this matter stands adjourned for a week.
Yes. Highly obliged, ma'am.
6 is connected with 7, my lord.
6 and 7.
May I have the
Obviously,
lordship-
counsel for the applicant in item 7.
may I have the lordship? I am between item number 10, lordship. I am the legal counsel, but my name is not on the call list, so I am not being the
So you are not aware of the case,
lordship.
but you are here
That's
mentioning. it.
lordship, I came to know just is a delay condemnation petition, lordship.
You wait, we'll condone the
Lordship,
delay.
lordship. Highly
How
obliged.
many days delay?
30 days.
You wait, we'll pass an order.
Need to your lordship.
You take our file and go through the petition. Yes.
So item number 5, this is
Hmm.
today is for bail.
Hmm.
The main witness, his evidence is very illegible. I just need some time to translate it to English. So 2 witnesses I need to translate. If I
You
inform,
do it, but Mr. Bhattacharya, you have just mentioned,
I
why
listen,
these adjournments are taken in bail
I'm
matters?
really sorry. Otherwise, I can from the judgment I can argue, but there's
You argue then, we'll see if it
from
is
the judgment I
necessary.
can.
Yes,
Daily list for admission, item 1.
yes, what is this?
Lordship, the appellant has been convicted under section 20C of NDPS Act, Lordship, and he's been imprisoned for 12 years, Lordship.
All right, so we'll admit the appeal.
Lordship.
Your name, please.
And thus, Lordship.
Heard Ms. M. Das, learned counsel appearing for the appellant, assailing the judgment dated 30/9/2022, passed by the learned special judge, Bongaigaon, in special bracket NAR, bracket close, case number 46, bracket VGN, bracket close, capital, stroke 2021, convicting the appellant under section 20 bracket capital C bracket close of the NDPS Act and sentencing him to undergo rigorous imprisonment for 12 years and also to pay a fine of rupees 1 lakh with default stipulation. The instant appeal has been preferred. Full stop. We have gone through the impugned judgment, admit the appeal, and also heard submission of learned counsel for the appellate. Stop. Ms. B. Bhuya, learned senior counsel and APP Assam, assisted by Ms. M. Chakravarti, has appeared on behalf of the state. Stop. Admit the appeal. Call for the LCR. Issue notice returnable in 6 weeks. Since Ms. M. Chakravarti has appeared and accepted notice for respondent number 1, no formal notice is required to be sent to the said respondent. The appellant to, however, take steps for service or notice upon the respondent number 2.
Lordship may not be required.
Who is
The
the
police officer, police person will do.
since the respondent number 2 is a police inspector, service of notice upon the said respondent is not deemed necessary in this case. As such, this matter is considered to be ready as regards service. Registry release this case immediately on receipt of LCR.
Obliged.
Is not considered necessary, or is deemed to be ready as regards service.
Yes, sir. For this, item 2.
Question.
Yes.
This case, the paper books are ready, my lord, but I find, my lord, the perhaps it has not been served on me, my lord. Someone else has received it. And the signature, some signature perhaps shows some B Datta or something like that. I'm not really sure. The signature is
Oh. They have lost sight of the M and given it to some other Datta.
Maybe
You have
nothing.
to be careful. You have to be careful. If everything goes to some other Datta, there will be problems. Heard Mr. M. Datta Leonard, amicus curiae appearing for the appellant, also heard Ms. B. Bhuya Leonard, APP Assam, representing the state. Mr. Datta submits that paper book is ready in this case, but the same has not been served on him. Full stop. It appears that the paper book has been served upon
I know some signatures there, but
served upon him. In view of the above, register to verify and serve the paper book on Mr. Datta within 2 weeks from today.
We have received the paper.
Let the matter be listed thereafter for fixing a date of hearing.
I just check the record once again. I hardly check it up. Madam.
You want to check after the order is passed?
No, I just again verify. Just I checked it once again. Madam.
Item 3.
I'm appealing on behalf of Mr. N. Hassan, learned amicus curiae, Your Lordship.
Yes.
The appeal has already been admitted, Lordship.
Hmm.
Paper
Anything-
book has not
Huh?
been received. Paper book has not been received.
We have received.
The learned counsel for the appellant submits that copy of the paper book has not been served upon him. Ms. B. Bhuya Learned, APP Assam, submits that paper book has been received by the state. Full stop. In view of the above, registry to verify and serve paper book on the appellant's counsel within 2 weeks. Let the matter be listed thereafter for fixing a date of hearing.
Item 4. This matter is that the victim being the deaf and dumb girl, and she was raped and she got pregnant and then she delivered a dead child. Now I have looked into the matter, Lordship, on the earlier occasion, Lordship said whether there will be any difference between the victim being a normal girl and a deaf and dumb. So I have checked, deaf and dumb, as your Lordship was correct in saying, she has the capacity to understand, she has the mental faculty intact. So she being the deaf and dumb, she had, in the particular case, she had expressed through the interpreter. She had shown the house of the accused that he is the person who did. 164, she said Mr. Sur had did the act with her. This one is Sirazul. So it
May it be the Lordship. Lordship, here in the appellant, he has been convicted under 302. The contention is that date of incident is 2/11/2011. On that day, the deceased, he had called up PW5 at around 10:30 and said that if anything happens to me, the appellant is responsible. He did not return home. On that night, 2/11, he did not return home. The father of the deceased, his PW3, he had lodged a complaint before the Nanoi OP on 3rd, saying my son has not returned. Nobody was named. In that, in fact, that complaint is not on record. Though the mention is there, the complaint has not been brought on record. That is of 3rd November. 4th November afternoon, his body was found in a paddy field. Sorry, madam, my learned friend has rectified it. He called up his mother at 10 o'clock. He called up PW5 and said at 5 o'clock that if something happens to me, the appellant is responsible.
PW5 is the mother.
No. PW5 is a friend of the deceased. He called up PW5 at 5 o'clock saying if anything happens to me, the appellant is responsible. Same day, 10:30, he calls up his mother.
No,
and
5 o'clock means what? In the morning? or
evening, 5 p.m.
6-7.
He calls up and says, yeah, if anything happens to me, appellant is responsible. There is evidence that at 10:30 same night, he calls up his mother and says, I'm coming home.
Mother is PW?
Mother is PW7, but mother does not say that. PW4, who is the brother, he says that he called up my mother. He called up, mother picked up and he said, I'm coming home. That is around 10:20, 10:30, same day, night. He did not come home on the 2nd November. He did not come home.
Hmm.
3rd day lodged an FIR before the Nanoi outpost, stating my PW3, who's the father. He said, my son has not come home. Matter ends there. 4th body is recovered.
It's
On
a
the-
homicidal death.
It's a homicidal death. On 4th body is recovered. When 5th an FIR is lodged, naming me, saying that I had committed the crime. Now, father in his evidence says that till the recovery of the body, PW5 has not stated that the deceased that called him up and said that if anything happens to me, the appellant is responsible. That is the evidence of the father. But the brother, who's PW4, he all throughout says that when the deceased did not come back home on 2nd, he went out looking for him. On 3rd, he met PW5, Mr. Nipen Sharma, and then the Nipen Borman. And then Nipen Borman said that I had received the call last night from your brother. And he said, if he does not return, the appellant is to be blamed. Now, the twist here is this Nipen Borman, he has recorded the conversation. He says he has recorded the conversation.
Nippon Borman is PW.
PW5.
Hmm.
He says he has recorded the conversation. This conversation is allegedly given to the police in a form of CD. The IO, PW15, he says, I have not sent the CD for FSL, not sent the phone for FSL. Whether it has been, whether the conversation has been.
What has he done with it?
He has done nothing. Moreover, I have checked the records. The IO says he has collected the CDRs. The judgment says the learned trial judge asks the PP that are the CDRs in record. PP says yes, but I have, subject to correction, I have not found. There is nothing on record to show what is the deceased phone number, what is the accused phone number, and whether there has been any calls between them at that point of time. If the deceased has called his mother, if the deceased has called the Mr. PW5 Nipen Borman, 2 numbers are ought to be there, time ought to be there, even that is not there. Only things the learned trial judge has taken that since the deceased has said, called up PW5 and said that if anything happens to me, appellant is responsible. He has taken it to be last seen together theory, because hearing is also a sense of perception. So I was found, it is assumed that I was with him. That's why it has happened. Now, last seen theory, if at all, it can be taken.
So, Miss, case of acquittal?
In fact, those his phone numbers were correct and all those can be gone into at the time of hearing.
We'll do it, but
Time
we'll
of
have
receipt.
which district is this?
This is not out.
No.
Let the SP come and sit here and tell us.
But as of now, in this 389 application, the prima facie materials that I wanted to point out, the victim used to work with the appellant in a garage. He was an employee. And then on that fateful day, both were together. He took him. Thereafter, he was missing. Missing entry was made at the police station by the father. They were searching for the body, and then 4th, they found it. 2nd, missing entry was made. 4th, the body was found. After recovery of the body, of course, PW5 stated that I got a phone call where he said, if something happens, then he'll be responsible. So that is on record, it is said. And thereafter, that was again corroborated by the brother of the deceased, who said, who were searching along with his father. And then while talking to PW5, PW5 said about him, about the phone call. They went to the police station. Then it was submitted. Every other witnesses also heard the phone call. Conversation was recorded. So phone call was there, other witnesses heard. And then, so these materials makes out a chain. As of now, in this 389 application. Now, CDR, it is said CDR was on record. Now, it is not in the record that I'll see during the time of hearing. But as of now, these materials are there.
No, you see, you can't, you means not personally you,
Yes.
or maybe these things can't be treated so casually. That
That is what-
we don't have it, we'll see it later on. Now let him remain in jail. Remaining in jail is not a very simple
Liberty,
thing.
of course, cannot be. This is, of course, the material that I have. And IO IO was, I have to see
15,
who was the IO if your lordship.
PW
wants.
15.
Huh?
If I can
PW
point out one
I mean,
part of
where
IO's
is he
evidence.
now and all? I'll have to find out again. If your
PW
lordship wants.
Sorry.
But this becomes a kind of dying declaration, section 32. It comes within the purview of section 32. The
Which
phone
one?
call made by the deceased to PW 5.
But why was it not been acted in accordance with law? That's the answer we want.
Certificate and all under
No.
65B, everything, I think, phone CDR, case detail record.
CDR, the judge, learned trial court says that since 65B certificate was not available, CDR was not exhibited. I could not find a CDR on record. As of the phone call, the CD and all, there is nothing on record that even 65B was applied.
That conversation was recorded in the mobile.
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 It is said that it was.
Why did he not seize the mobile?
It was seized.
It was seized and given to Zimma again to that person. The Zimma Nama is there. I get exhibit 4 or 5.
Mobile was given back. The conversation was.
If I may read one paragraph of the cross of the IO, just one paragraph. PW 15. The
Yes.
FIR was lodged on 5/11/2011. The informant on 3/11/2011 lodged a missing entry, and the same is not sent to the court with the CD. The FIR dated 5/11 is the second FIR in connection with the case. Mobile was seized on 5/11. Nripen Borman, that is PW5, himself submitted the compact disc containing the data from the mobile phone, and the same was prepared by him. So this PW5 himself had done. He had said that by Bluetooth I had transferred it, made the CD, given to police. Prepared by him. CD was not sent to FSL for authentication. I did not send the call verification list to the court. It is not stated whether the seized mobile was an ordinary mobile or some smart Android phone. I do not know whether it contained Bluetooth features.
So we want the IO and the SP or additional SP to come and explain it to us. What is this going on?
I can check the case record.
We'll have it on Tuesday. You also file your evidence, whatever. You tell them to come. You tell them to come and explain. What is this kind of investigation in this? We want to know. It's getting beyond tolerance now.
Before that, if your lordship allows, I'll go through the case diary once again.
We'll go through the case diary. We'll take it up. We'll pass the order. We'll have it on Tuesday.
Lordship.
But you ask the IO and
Yes,
the
I'll find it out. in the
SP or
meeting.
additional SP to come and explain it to us that in this case, why the investigation was conducted in this manner. We want to know. In the court, in the live streaming, they will have to explain it to us. Let the country know about things. That order will be passed. Give me the name of the SP
Tuesday,
and whoever. Yes,
Tuesday.
yes,
the
coming Tuesday.
Lordship, and
We can pass the order a little later. You can communicate with them and give us the details. In these serious, heinous crimes, serious matters, this is the casual manner which they do it. They will come here and explain it to us why these things were done, and we'll have this recorded clippings. Of course, it will be streamed live, and we want the society to also know the casual manner in which the police is handling investigation in criminal cases. Please find out and tell us at 2. Speak to the SP. Tell him that this is court is very, very annoyed, and you have to give an answer or you have to come.
At
Tell him.
2.
At 2.
At 2. I'll
Okay.
get his.
Yes.
Lordship, on behalf of the respondent number 2, informant. Much God bless you.
What is your name?
On behalf of A. Kakute R. Das.
You come at 2 again. We'll take up the matter. You go through the record and tell us what is the matter.
I'll just go.
The interest of the society cannot be left
Yes, of course.
unaccounted in the hand of some callous, cavalier police officers who are neither interested nor have the know-how nor the motivation. We cannot be a silent spectator to this anymore.
And that being the only evidence, rather.
Why has he not dealt with this evidence in accordance with law? We want to have that answer from the SP. He has to come on Tuesday and give us that answer along with the IO. We are passing that order. You tell him. If he has anything to clarify in the meantime, that's why we are putting it at 2.
Not. Obliged. 8, Lordship, item 8.
The
Lordship.
SP now may not be personally concerned, But he is a police official, he is in charge, has to tell us, he or she, whoever it is, what is happening. Let him come and tell us. Yes.
Item 8, what had happened, this was I am mistaken a little. Here I was supposed to get the instruction from the OC Sibsagar where the notices were served upon the accused. This is an appeal against acquittal filed by the state. I spoke to him on that day and then he was getting transferred on that day itself. Thereafter, I took the phone number of the other person. Lordship will give me tomorrow or day after. He called me up in the morning. And then he said that I'll have to trace out the report and send it by tomorrow, day after he's sending it, the report.
On the request of Ms. S. Jahan, APP Assam appearing for the state, this matter stands adjourned and shall now be listed again on next Wednesday.
Lordship of that. So did John.
Item 9.
May I please, Your Lordship?
Yes,
The additional affidavit file has already been taken to the record, Lordship.
what happened?
Here, Lordship. Lordship, this appellant, Lordship, appellant petitioner, by the order of this honorable court, he surrendered on 1/6/2022. And after surrendering, Lordship, some health issues came up, Lordship. He was taken up to Nemcare and Netralaya on 8/11 and 12/11, Lordship. And Netralaya, Lordship, the records are here. They suggested him for an operation. But since there is a stain in his heart, Lordship, that required to be removed, the operation could not be done. And tomorrow again, for his review, it is. So Lordship, kindly take up page number.
First of all, what is his IA for?
This IA, Lordship, is to bring on record the complications, medical complications that he is facing, Lordship.
Hmm.
All we have annexed all the medical documents so far we could get, Lordship. And page number 92, Lordship. There, Lordship, he was taken on 23/11. He was advised to come back after 15 days in the.
Page number 92
Of the additional affidavit recently filed by us. We filed it, Lordship.
recently means give the date.
30. It has been filed on 30/11, Lordship. There, your Lordship will find that 23/11 he was brought up for a checkup and he has been asked to come after 15 days. That will be, if I am not wrong, will be tomorrow, Lordship.
Yes, so what is this about? What is your stand today?
Lordship, I have actually this IA has been filed taking a ground that to extend even interim bail, Lordship, because he is to be operated.
Hmm.
His eyes are to be operated. We are praying that after again 30 days, Lordship, he will surrender.
He's 92, she's a psychiatrist, psychiatric consultation.
Have you received a copy of the affidavit?
No.
Lordship, since he is undergoing, Lordship, he is in Udalguri jail.
Hmm.
Lord, may I suggest he may be transferred to Guwahati jail, your Lordship,
Hmm.
and so that he can be treated here. Because from Udalguri jail, they have to make arrangement for all these escorts and all, convoys has to be given.
So what is the procedure? What is
They arrange all this security and all that, thereafter they send.
No,
Because,
that's right.
yes,
So, to transfer him to Guwahati jail,
yes.
what is the procedure?
Procedure, I think, because he is taking treatment in Guwahati, the Sankadev Netralaya as well as name care, your Lordship.
Hmm.
So, Lordship, he may be transferred here. Procedure, I have to take instruction, my lord.
No, if I may kindly submit, Lordship.
Hmm?
He is a resident of Udalguri, Lordship. And
Forget all those things.
no, I have just one point to submit, and it is up to the honorable court. Lordship, his family members can only constantly have a take care of him, Lordship, because they are also in Udalguri. For them coming to Guwahati each and every time, because Lordship, he is on diabetic dietary. So which is not available in the jail.
No, jail authorities have given this instruction. He has been provided with instruction dated 2/12. All
You
diabetic
tell your
diets.
jail doctors that they are not supposed to address letters to the judges.
Yes, yes, sir.
You please tell him.
Yes,
Otherwise,
yes.
we'll ask
Yes,
him to
yes.
come here and talk to us.
Lordship, they are not aware of
Because
it.
that
Yes,
happens
yes, yes.
again,
Yes,
we will respond to it in a
Lordship.
different. That is none of his business.
my lord.
You tell him that.
Yes, my.
And otherwise, Lordship, each and every time when this honorable court was pleased to give it interim, he has surrendered.
No, no. So now what is that you want? You want to go on bail
Lordship,
for how many days?
30 days, Lordship.
For what purpose?
Lordship, he has to be operated, Lordship.
Where is the prescription?
Lordship, kindly see the Netraloids that is in page number 109, Lordship. 108 and 109. Surgery schedule, Lordship. Only because there is a stain in his heart, Lordship, he could not be operated. It is supposed to be removed tomorrow, Lordship.
That was November 12. It is already gone.
Yes, Lordship, because of that stain in his heart, Lordship. The
So
operation.
what is the next? What is the surgery?
Tomorrow, Lordship, tomorrow he has to be produced before the cardiologist. And if his heart condition is fine, then the stent will be removed. And then he'll be operated, Lordship. Tomorrow is the date for
Is it
review.
so?
Lordship, their records, their whatever they have given, Lordship, the certificates and all medical certificates, it's there for checkup at page 118. CAG on next visit.
What is CAG?
Coronary angiography.
No, Ms. Bhuya,
My
give
lord.
us some clarity. What is to be
Yes, your
done?
lordship. No, my instruction, whatever I have got, my lord, they say, therefore, the certificate of health status of producer would have to be collected from Sankardem Netrala Guwahati Name Care Super Specialty by the dependent, but they have already submitted whatever is there, your lordship, in the additional affidavit. Lordship, tomorrow is the date, he may be provided with the treatment, your lordship. Because
Yes.
yes, because there are orders from this honorable court earlier. If it is, whenever it is required, he will be given treatment as well as dietary
That order is already there.
already there.
Tomorrow let him be produced. Lordship, may I make one submission, Lordship? Tomorrow let him be produced, Lordship. And if in case the medical is prescribing for a surgery, I would pray for an interim relief, Lordship. For an interim relief.
Lordship, let him do checkup tomorrow. And
Mr. A. Bhattacharya, learned counsel for the applicant, submits that the next medical checkup of the petitioner of the applicant is fixed tomorrow at the Namcare Hospital in Guwahati.
Lordship.
And if his condition is found to be suitable, then the applicant may have to undergo
Operation.
surgery, eye surgery
Eye surgery.
the name care hospital.
No, at Netralaya.
Netrala,
at the
yes.
Sankar Netralaya Guwahati. First up, the applicant therefore seeks his release on bail for a period of 30 days on medical ground.
Lordship.
First up, Ms. B. Bhuya, learned APP Assam, prays for a week's time to seek instruction and respond to the prayer of the applicant insofar as the prayer of the applicant for releasing him on bail for 30 days. First up, in view of the above, let this matter be listed again.
Lordship, I'm sorry. Lordship, if health condition is such like that, your lordship, he may be released. Fixed date be given. Let the matter come up after a week, your lordship. In the meantime, my lord,
After a
if,
week?
yes,
In the meantime, the applicant shall be
yes.
provided all facility of treatment as
Yes.
per the earlier order of
Yes.
this court. Yes.
Deep level.
Item 10.
Yes, the Lordship, I have put a delay consumption of 30 days.
Lordship, may we
Will
confirm?
condone the delay
Not-
to take down heard Mr. N.J. Gogoi, learned counsel appearing for the applicant. We have also heard Ms. B. Bhuya, learned senior counsel and APP Assam, assisted by Mr. J. Das, appearing for the state. This IA has been filed under Section 5 of the Limitations Act 1963 with a prayer to condone the delay of 30 days in filing the connected criminal appeal against the judgment dated 23, against the judgment of conviction dated 23/6/2022, passed by the learned Sessions Judge Golaghat in connection with Sessions case number 15/2020. Full stop. Peruse the IA wherein explanation for the delay has been furnished. Full stop. Also heard submission of learned Mr. N.J. Gogoi, learned amicus, your legal aid counsel,
Legal consumption.
learned legal aid counsel appearing for the applicant. Full stop. Ms. Bhuya, learned APP Assam submits that she has no instructions to file objection opposing the prayer made in the IA. Full stop. In view of the above and considering the explanation furnished by the applicant, we are of the opinion that the applicant was prevented by sufficient cause from filing the connected appeal within the statutory period of limitation. In view of the above, the delay of 30 days is hereby condoned. Office to register the connected appeal and list the matter for admission, IA stands dismissed.
So my name is on the coordination.
And list the for admission by reflecting the name of Mr. N.J. Gogoi in the cause list.
Highly
IA stands declared.
Item 11.
Rajimul, Rajimul,
Lordship, this IA is for condonation of delay for 198 days. Filing the appeal, 198.
Judgment of conviction,
Yes, Lord.
Lordship, maybe.
198 days, and you change the number of the judgment is 4/3/2022, passed by Special Judge Pokso Pokrajhat in special case number 22 of 2017. Rest will be the same.
Obliged.
Showing the name is not required.
Yes, Alam.
Yes, sir.
Supplementary list for hearing part of letter item 13 and 14.
May I please, Lordship? Lordship, first, Lordship, may I please submit on this Oshini Polika petition, Lordship? I have read it, and my humble submission is distinguishable from our case, because in that case, my first submission that the mandatory requirement of section 164, section 4 is not fulfilled. That was not there in this case. And read with the Dhananjay Reddy judgment that says that it is not curable under section 463 of CRPC. That by oral evidence, that any defect can be ignored by the court, taking oral evidence. That is an exception to section 91 of evidencing in the 463 CRPC. Court has the power to ignore the defect under section 463 CRPC, taking oral evidence of the magistrate into consideration. But Dhananjay Reddy judgment is clear that this mandatory requirement of non-compliance of this mandatory requirement of 164(4), 2 or 3 cannot be cured by 463 CRPC, resorting to 463 CRPC.
Do you have a written note of your submissions?
Of today and all, I submit I will submit. Now, another, in that case, in paragraph 78, it has been held that having regard to the evidence available on record, we are of the opinion that this is not a case where the prosecution case was entirely based on confessional statement of the accused. Because there are other circumstances leading to discovery was there. It was proved. In our case, these things are not there. Other circumstances are not proved. Only confession is main. And confession has been linked with CDR and 164 statement. As like 164 statement of the PW6, 164 subsection 5. It also goes because he was not declared hostile, and that statement was not brought on record. Exhibiting it because it is not a substantive piece of evidence, it cannot be taken into consideration. That only once confession is there. And CDR is not proved by calling for any witness. Even the CDR is not certified by any officer of the nodal officer of the service provider or any certifying officer. They are not examined. They are not there. They are not examined also. So CDR is not proved. As per, may I please submit a decision on this, that how a CDR can be proved. There is 2005 volume 11, page 600. Is it from?
It is there in the compilation.
It is not in compilation. Separate. They have printed. I have given the list here. 2005 11. 600. 600.
670.
600. Paragraph 150.
Paragraph 150.
150. But may I please read from 148, Lordship, because 150 is the final conclusion.
Yes.
148 paragraphs. Call records, proof and authenticity. 140. It is contended by Mr. Shantivishan, appearing for the accused Shokat, that call records relating to the cellular phone number 9811573506 said to have been used by Shokat have not been proved as per the requirements of law, and their genuineness is in doubt. The call records relating to the other mobile numbers related to Dilani and Afzal are also subjected to the same criticism. It is the contention of the learned counsel that in the absence of a certificate issued under subsection 4 of section 65B of the Evidence Act, with the particulars enumerated in clause A to C, the information contained in the electronic record cannot be adduced in evidence, and in any case, in the absence of examination of competent witness acquainted with the functioning of the computers during the relevant time and the manner in which the printouts were taken, even secondary evidence under section 63 is not admissible. 149. Two witnesses were examined to prove the printouts of the computerized record furnished by the cellular service providers, namely Airtel, Bharati Cellular Limited, and SR cell phone. The call details of mobile numbers such and such are contained in exhibits 36 by 1 to 36 by 2. The covering letters signed by the nodal officer of Sterling Cellular Limited are exhibits P36 by 6 and P36 by 7, bearing the date 13th and 18th December respectively. The call details of mobile number such and such attributed to Afzal are contained in exhibit P36 by 3, and the covering letter addressed to the Inspector Special Cell PW66 signed by the nodal officer is exhibit 36 by 5. The call details of 98100812228 belonging to the subscriber SAR Gilani are contained in exhibit 35 by 8. The above two forms were contained on cash card basis. The covering letter pertaining to that to certain other mobile numbers were signed by the security manager of Bharati Cellular Limited. The call details relating to another cell phone number such and such pertaining to Muhammad, he is exhibit 35 by 5. These documents, that is exhibit 35 series, were filed by PW35, who is the person that signed the covering letter dated 17 December, bearing exhibit 35 by 1. PW 35 reports that all the call details are computerized. Sheets obtained from the computer. He clarified that the switch the switch which is maintained in the computer in respect of each telephone receives signal of the telephone number called or received and serves them to the server, and it is the server which keeps the record of the calls made or received. In case where the call is made and the receiver does not pick up the phone, the server which makes the loop of the route would not register it, unquote. As far as PW 36 is concerned, he identified the signatures of the general manager of his company who signed Exhibit P36 series. He testified to the fact that the call details of the particular telephone numbers were contained in the relevant exhibits produced by him. It is significant to note that no suggestion was put to these two witnesses touching the authenticity of call records or the possible tampering with the entries. Although the arguments have proceeded on the lines that there could have been fabrication, in support of such argument, the duplication of entries in exhibits 36/2 and 36/3, and there was some discrepancy relating to the cell ID and IMA number of the handset at certain places was pointed out. The factum of presence duplicate entries was elicited by the counsel appearing for Afsan Guru from PW 36 when PW 36 was in the witness box. The evidence of DW 10, a technical expert, was only to the effect that it was possible to clone a SIM by means of a SIM programmer, which to his knowledge was not available in Delhi or elsewhere. His evidence was only a general nature and this is a theoretical possibility and not in reference to specific instances. 150. According to section 63, secondary evidence means and includes, among other things, copies made from original by mechanical process, which in themselves ensure the accuracy of the copies, and copies compared with such copies. Section 65 enables secondary evidence of the contents of a document to be adduced if the original is of such a nature as not be easily movable. It is not in dispute that the information contained in the call records is stored in huge servers which cannot be easily moved and produced in the court. That is what High Court has also observed in at para 276. In printouts taken from the computers, servers by mechanical process and certified by a responsible official of the service providing company can be led in evidence to a witness who can identify the signature of the certifying officer or otherwise speak of the facts based on his personal knowledge. Irrespective of the compliance with the requirement of section 65B, which is the provision dealing with admissibility of electronic records, there is no bar to adducing secondary evidence under the other provisions of the Evidence Act, namely section 63 and 65. It may be that certificate containing the details in subsection 4 of section 65B is not filed in the instant case, but that does not mean that secondary evidence cannot be given, even if the law permits such evidence to be given in the circumstances mentioned in the relevant provisions, namely section 63 and 65. In our case, no nodal officer or certifying officer has been examined. Even the purported seizure, it is apparent from that it is not certified by any officer of the service provider. Apart from other discrepancies or with the number, who has called, whose number, the particular number belongs to whom, and what is the number of the victim, these are not in evidence on record. So this seizure, if it is not admissible, it cannot be a chain or corroborative proof of confessional statement, apart from inadmissibility of confessional statement. Next lawsuit I get to submit on, I have been convicted on 120B also. For 120B, it is settled that an agreement, prior agreement has to be proved, either by direct evidence or circumstantial evidence. So here also to prove this only confessional statement.
So, Mr. Purkastu, if the confession goes, conviction goes. If the confession stays, conviction stays. Do you agree with that?
Yes.
That's the only issue here.
Yes.
Nothing else.
Yes.
Rest of the things are all there.
Yes, Lordship. Yes, only just another decision I get to just submit on. This is because this is an acid attack case. Perhaps if confession goes, only moral things subsist here. Perhaps
No, there is nothing moral. This is a acid. There is no need of any further proof. That you can argue. but
legal,
we can tell
legal
you.
proof. What I'm
There is no
submitting legal
need
proof.
to get a doctor, medical, FSL report, these, that. Liquid thrown, people had burn injuries. That is obviously acid. It will not happen if Ganga Jal is thrown. So let's not take the law of proof to such a stultifying level. Of course, this is acid. We'll say that it is acid. Only question is whether the confession could have been acted upon or not. That's the only question here, nothing else. If the answer is yes, the conviction will be upheld. Nothing else
Yes,
is here.
yes.
We have seen it yesterday. You may take us this way, you may take us that way, but these are all arguments for the sake of arguments. There can't be a perfect.
These are supporting arguments. Main arguments is on confession.
Yes, yes.
Main is on confession.
Yes. Well, the court must feel that there is something seriously wrong with the confession.
Yes.
Some technical cosmetic areas here and there, we'll see how it affects.
If and Lordship in Ashwini Kolita case, the two judgment I have relied upon, this is Dhananjay Reddy. There is and there is Aloknath Datta.
Those were not considered.
Yes, Lordship.
Hmm.
It will make difference with the facts of this case and the argument of this case also.
That we'll have to see.
Because this Dhananjay Reddy paragraph 20 and 21 clearly says it is not curable. These are mandatory requirement. Shoran Rattan Singh says these are 164(2), subsection 2, 3, 4. These are mandatory requirement. All other decision says, and Dhananjay Reddy says it is not curable. Non-compliance of this is not curable, even by model evidence. There is an exception in 463 CRPC, but it is not curable. Even under 463 CRPC. Dhananjay Reddy holds the field here strongly.
Yes.
Then, Lordship, I need not to go other decisions, only this. In compilation, my decision that there are notes also regarding compilation, and I will submit a written synopsis.
That's all.
Yes, sir.
Lord, I am for accused appellant Dipendas. His conviction, my lord, based on my lord confession of the co-accused.
Yes.
So, my lord, as for Horisharan Purni's case, Lordship has dealt in my lord Ostini Nas's case also. Which should not start with the my lord the confession of the co-accused. It has to look other evidence, my lord. Thereafter, the court convinced my lord, then only it should look into the my lord the confession of the co-accused.
Prosecution case cannot be based entirely on confession of the.
Yes. So, my lord, the circumstances, my lord, which were taken against me, that is in para 66 of the judgment, my lord.
Yes.
That page 66, my lord. Page 100. Page 100, para 66. May I just read it, my lord?
Yes.
In view of the corroborated chain of events, shifting of mobile shop of Anaruddin near to accuse Nipendas's mobile shop even after his objection. That is one, my lord. Then threatening by accused regarding future problem to be faced by him. That is number 2. Differences between accused and victim. That is number 3. These 3 will be mainly for the purpose of motive, my lord. Then next is, my lord, missing of footage from the CCTV installed at the shop of Nipendas during the time of incident. Then number 4, my lord, recovery of mobile phone from the possession of the Nipendas, which used for making threatening calls to the victim not to come back to Longding, clearly suggests that Nipendas has committed the offense of throwing acid upon Anaruddin by engaging Ahang Wansa due to business rivalry. That means, my lord, by engaging Ahom, I have, my lord, made the all plan and committed the crime through Ahom. And next, my lord, over and above from the clear suggestion of accused Ahan Wangsa and statement of witness Manai, that is PW6, my lord. It is proved beyond reasonable doubt that the accused Dipendas has hatched the conspiracy against Anaruddin and caused the present offense, engaging accused Ahan Wangsa paying money for the same. So these are the circumstances, my lord, the learned trial court has relied on. So, my lord, my learned friend has already argued regarding that, my lord, the CDR, my lord. So coming to the CDR, my lord, first I will just point out, my lord, the exhibit at exhibit 3 at page, my lord. Seizure memo, my lord. First I will come to the seizure memo. Seizure memo at page, my lord, 110. Everywhere it is written, my lord, learned court has come to a finding that it is from the possession of the, my lord, the accused Nipendas. That mobile, yes, phone, my lord. But just I want to point out from 110, my lord. First date is, my lord, date of seizure, that is 4/3/2019 at 19:20 hours. Place is the Das Mobile Center, that is my shop, my lord. Here, my lord, if I just seizure memo, I point out, my lord, this IO, my lord, Wangsa has seized the following described ITR mobile phone on conduct of search of the shop of alleged accused Das Mobile Center and on being found in the shop before the signed witnesses. First, my lord, ITL mobile phone, model, color, black, IEMEI number, it is, my lord, not mentioned. So then, my lord, how the IO has got the IMEI number, my lord? He speaks about the IMEI number, but very basis, my lord. This is the seizure memo. From this seizure memo only that, my lord, the handset was seized. And on that day itself, my lord, he did not record the, my lord, the IMEI number, my lord, which is very, very important, my lord. Because every mobile has got, my lord, each individual, my lord, this IMEI number. And from this only, my lord, there's all these CDR, etc., call record, etc., can be, my lord, looked into, my lord. But this very, very foundation, my lord, this IMEI number is missing, my lord. And there were, my lord, 4 seizure witnesses while doing the, my lord, this seizure. Not a single, my lord, witnesses, these seizure witnesses were examined. Section 100 CRPC, my lord. Nearby, my lord, some, at least 2 witnesses would have been there. They have taken in the, my lord, seizure memo 4 witnesses, but none of them has been examined, my lord. So whether there is any, my lord, value of this, my lord, seizure memo? And, my lord, most importantly, my lord, this seizure was done on 4/3/2019. And on that day, my lord, this accused appellant, he was in jail, my lord. He was arrested on 1/3/19. So not from his presence, my lord. And, my lord, coming to exhibit 4 now, my lord, at page 112. By that seizure memo, my lord, 99 numbers of Vodafone SIM and Airtel SIM 116 numbers.
Page 100 and
Page 112. Next exhibit, my lord. So, my lord, this date of seizure is on 28/02/2019, my lord. Prior to the day, my lord, when this Nipen Das was arrested. Nipen Das was arrested on 1/3/19, my lord. This is also, my lord, on that day, my lord, this same, my lord, police officer, my lord, he has seized this SIM from my shop in presence of Nipen Das. Nipen Das was present on that day. And most importantly, my lord, on that day, my shop was, my lord, seizure was made from my shop. But that day, my lord, that mobile could not be found. So in between 28 and 4th, my lord, how that mobile has come, my lord. And on 28th, my lord, my presence is there. My signature is there. I was there. At page 113, Lordship will find at the top. C is from SD Elizabeth Nipen Das. So, my lord, how that handset has come in between these 3-4 days in my absence, my lord. Because for CDR, that is the link, my lord. That is that from handset, my lord, that threatening call was given to the, my lord, the victim before and after the incident, my lord. And if we now come to the, my lord, call record, my lord, Lordship will find at page 119.
119.
119. That is, my lord, CDR. My learned friend has already argued, my lord. That has not been proved in accordance with law, my lord. This has been simply exhibited by the, my lord, the IO. This contains 2 pages, my lord, 119 and 120.
Yes.
Here, my lord, the mission, that is the, my lord, the SIM number at the top, my lord, very first line, 76408-60421. No witnesses stated, my lord, that this SIM belongs to, my lord, Nipen Das. Because this call was received from an unknown caller, as stated in the evidence, my lord. So no, we from the evidence, my lord, nowhere we find, my lord, that these SIMs belongs to Nipen Das. And my lord, subsequently, if we come to the call records, my lord, this particularly on 13th February at 24 hours, that is at night 8:24 hours. It is stated that IO has gathered, my lord, that he has come to know. If I come to the evidence of IO, it will reveal that he has come to know that 8:24 on 13th February 2019, a threatening call was given, my lord. But the person, my lord, who has received the threatening call, he was not examined. This call came to, my lord, this Anar's place as he was injured, my lord. This phone was received by his elder brother. So his elder brother not examined, my lord. And nowhere, my lord, we find Anaruddin's number. Which is Anaruddin's number, my lord? On 13 February, my lord, 2 calls, outgoing calls were received, my lord. One at 20:24 at 15 second and another as 20:27. From 2 different numbers, my lord, 2 calls were received, my lord. Calls were received in these 2 numbers, my lord, 0825801112 and 0, my lord, that call CDR, that, my lord, party numbers, B party numbers, last 2 numbers, my lord.
Yes.
And my lord, the IO and IMEI number, which my lord IO has stated that he has got the IMEI number. If we come through the my lord, this call details, my lord. Nowhere lordship will find this IMEI number. Only in the my lord page number 120, lordship will find. Down below, simply that IME number has been written, my lord. Lordship will kindly come to page 150.
115.
120.
115.
Second page of the my lord, this CDR.
Yes.
In the printed form,
Hmm.
lordship will nowhere find the IMEI number what my lord the IO has stated.
Hmm.
These are two different numbers. That different numbers he has written my lord down below by hand.
This is called IM.
EI number. We'll come to KSL, interim. That is the identification of the mobile, my lord. And each and every mobile has got this number, my lord. If a mobile has got my lord two SIM cards, my lord, then there will be two EMA number, my lord.
Yes.
So if we come to the my lord, the evidence of the IO, my lord.
Yes.
PW 78, my lord, it starts at page 17.
Page 17.
Page 17, my lord, yes.
Yes.
We come to my lord, the page 18, my lord.
Yes.
Top, my lord, during investigation, it was revealed that on 13/02/2019 at around 20:24 hours, victim Anaruddin received a threatening call from unknown person number from so and so to face dire consequences. But my lord, Anaruddin never speak of this date and time, my lord, and number also. Because IO is not the my lord, he is not a direct witness, my lord. Whatever you will collect, my lord, during the investigation from the statement of witnesses, other things recorded, my lord, from there only he will depose. When my lord Anaruddin has deposed, my lord, he has never given any date, time, specific time, my lord, that he received a call on such and such date at such and such hour. And my lord, I have failed to collect the my lord, the mobile number by which Anaruddin received the call, my lord. That would have been the best piece of evidence, my lord. If that number would have been obtained, my lord, that CDR of that number could have been, my lord, obtained. And by that, my lord, it could have been proved that I have made, my lord, call through Anaruddin to Anaruddin from, my lord, that ITL phone having the, my lord, the specific that, my lord, IME number, my lord. Then, my lord, may I just read? He has already read, my lord. My friend has already read.
Achha, where is the confessional statement or statement of under 164 of Manai Wangsa?
Yes,
Where is it?
I will come to that, my lord. While, my lord, examining him, my lord, what was not exhibited?
What got executed?
That, my lord, the statement of Manai,
Ah,
164 statement.
hmm.
He is a witness, my lord. He is PW 6. But that was not before brought, my lord, at that time while he was examined. Which ought to have been brought, my lord, that you have made a statement before magistrate under section so and so. This is your signature and all. Nothing,
Achha, let us see the 164 statement of Manai
my
Vansa,
lord.
and then we'll go to his evidence.
Okay.
So what we suggest is, we'll have a 5 minutes break and
My
then
lord,
we'll
my lord.
start. We'll go ahead with it. Mr. Chaudhary, you have to make his argument that 164 is defective.
May I read it, madam?
Yes.
On 18/1/2018, I came to Longding from my village Kunsa to play football tournament. As I was the goalkeeper of the team Kunsa Football Club, along with my team member, and thereafter I started staying at Longding in Puam Wangnau's rent house as he is my friend. He was also one of the accused. He was acquitted, madam, Puman. And after a few days, I started to take tuition classes for class 1, upper KG and lower KG. One day, Ahan Wansa called me in my mobile phone, asking me and Puman Wangon to come to market, but we denied to come to the market. And we disconnected the phone. After that, he came to the rented house where we were staying, running, and asked us to come to the market. Thereafter, I and Puman Wangsa accompanied Ahan Wangsa to the market, thinking that he wants to buy something from the market. On reaching market, Ahan Wangsa took us to Nipendas alias Kala's mobile shop, and there Nipendas and Ahan Wangsa went backside of his mobile shop, and thereby both started speaking secretly there. I heard Nipendas saying, "Jo bhi bola, oh, oisa karo." Whatever I said, do it accordingly. Then Ahan Wangsa asked me and Puman to wait for him near Anwar's shop. Then we came downstairs from Anwar's shop, and from there I went for urinating at the backside of the bookstall. And I came back after urinating. I found Puman smoking near Anwar's shop. So I also went near Puman, who was at Anwar's shop. There I saw one person coming from downside area of Anwar's shop wearing dust mask in his face and putting both his hands backside of his body, carrying one jug. When I saw that person near, I recognized that a masked person is none other than Ahang Wangsa. I recognized Ahang Wangsa, his clothes, physical appearance, and also the cut mark on his right cheek of Ahang, which was clearly visible, as the dust mask does not cover whole face. After that, Ahang Wangsa came to Anwar's shop and threw a jug of acid on his face. After that, Ahang Wangsa ran from the scene, and Anwar also started crying and shouting in pain. After seeing all this incident, I and Puman went back to our rented house in a shop. While returning to the house, we found Ahan standing near the shop near Labor Street Colony, in between Circuit House and Helipad Longding. Then there he didn't speak to Ahan, and we directly went to our rented house. At around 8 to 9 p.m., when we were sleeping, at that time Ahan Wangsa also came and slept on his bed without speaking to us. On the next morning, my tuition students came to our rented house, and thereafter I started taking classes for them. And from there on, I started avoiding him and stopped talking with him. After a few days of the acid attack incident, Ahan went to Pongacho. On 5/3/18 at around 9 to 10 p.m., police personnel came to our room and took me and two of my friend Bokai Wangnao and Wangsa Wangsa. This date will be 5/3/19, my lord, not 18. These two boys came from Khunsa village to do daily wages work to police station and inquired about Ahan, and I informed the police personnel that Ahan went to Pongachao, and after that we were dropped to our rented room and we slept. On the next morning, when I was coming back after attending church near Circuit House, I saw police vehicle near our rented house, and I saw police personnel bringing Ahang Wangsha from our rented house. I was waiting near the police vehicle, watching Ahon and police coming towards the vehicle, and when they reached near me, the police personnel asked me to go inside the police vehicle. I thought the police personnel wanted me to interrogate, so I went inside the police vehicle.
So this is his 164
164
statement.
statement.
Now let us see where is his evidence.
Evidence, madam.
He is PW6.
PW6. At page 15, 15.
Yes.
On the date of incident, I along with Ahon and Puman went together. Puman was with me. Ahom went to the residence of his brother. Ahom has asked us to meet him at PK Mobile Shop. Accordingly, I along with Puman went to the mobile shop and was waiting for Ahon. During that time, I have heard the sound of shouting from the mobile shop and turned towards the mobile shop to see regarding the shouting. I could not identify the person as to who has thrown acid to the shopkeeper. The boy who has thrown acid ran away from the place of occurrence before being identified. On that night, I stayed with Ahon and Puman. After 2 days, they went to their village and I was at Longding. Police arrested me. On the next day, police has arrested Ahon as we were together. Allegation against me for arrest by police that I was with accused person Ahom and Puman. The accused person, namely Puman and Ahon, are identified by witness.
So he did not support the prosecution case.
He did not support the proceeding. Neither he was declared hostile also. And most importantly, my lord, his 164 statement, my lord, that was not, my lord, brought into record through him. Because it was his statement.
But that's right, but he did not state the manner in which he had stated in his 164.
Yes.
That itself is good enough. Prosecution
That,
case.
my lord, the trial court has, my lord, hold that, my lord, he is hostile, he turned hostile. Trial court has hold like that he turned hostile.
No. It's nothing. It's just that PW6 evidence or his 164 statement will have no value, no bearing in this case. That's all.
My lord,
Rest of the things are all meaningless.
my lord.
PW6 would have no effective role in this case. That's it.
My lord.
His testimony will have no bearing. He has not implicated anyone in the deeper.
Yes, he's in a substantive evidence, my lord, he has not
That's all. He has
implicated
not
anyone.
implicated the
He has not
accused person.
implicated anyone.
That's what is material, and that is the only thing that we will consider here. What he said in 164 doesn't have anything to do.
Yes, my lord, but trial court has, my lord, taken that it has corroborated with the evidence of the, my lord, the
No,
confession.
that is wrong. That is wrong.
That is
There's no
wrong.
corroboration. Who has corroborated it?
Trial court has told that, my lord, that Ahon was
First of all, it is not even on
not in
record.
the record, my lord, it is not in record. It has been brought
So that is
subsequently.
gone. 164, that
It's gone.
statement is gone.
Yes,
And what remains is his evidence where he has not implicated. the
implicated
accused.
anyone, my lord.
All right. So this is what happens.
Yes,
As we have been saying, it is very easy to get out in criminal cases because the IOs don't know how to investigate, the prosecutors don't know how to prosecute, and in many cases, the judges also don't know how to write a judgment properly. So that is how things happen in this country. And maybe this is where it is heading towards. And there will be no change. Nobody will do anything about it. We will play our role as appellate courts, that's all. What can you do? The governments will not improve it. For the state, it is not a priority. So, in fact, this judgment should be written by AI. Just find out the 2-3 loopholes and acquit. There is no need for judges to even do it. It's so simple and straightforward. There are umpteen numbers of loopholes in every investigation, every trial. And at the appellate stage, just 5-6 loopholes are exploited, and that's all. That's the end of the matter. We don't know what will happen here, but it's pathetic again. It's just pathetic. Yes.
So, my lord, this is one of the circumstances also, my lord, taken against me, my lord. That confession of Ahon has been corroborated with the, my lord, the 164 statement of Namai, PW6.
That you are correct. That's the salutary legal principle.
Then, my lord,
This 164 statement would be used to corroborate his.
either corroborate or contradict, both
They
it
have
can be
neither
taken.
been corroborated. Contradiction, this question doesn't arise because he has not been cross-examined by
Cross-
anyone. The defense has declined his cross. Obviously, they
Because
will.
he didn't speak
Because
anything,
he has
why to
supported the
cross,
defense.
why to cross?
He supported the defense.
Well,
They should have. This evidence is binding on the prosecution. Anyways, we'll see.
Then, my lord, the other circumstances which has taken, my lord, that CCTV footage, my lord. CCTV footage, except Anaruddin, the victim, no one has stated in their evidence.
There is no CCTV footage here. It has not been seized.
That is not seized.
So how can we give an opinion on an imaginary
Yes, my lord. And
item?
how Anaruddin has stated, that is also not known, my lord. He told that from my shop, my
No
lord.
evidence in my lord. Yes, Mr. Let's finish it off.
My lord, may I submit, my lord?
Hmm.
First, my lord, your lordship has asked, my lord, about the 164 statement, my lord. Whether it was voluntary, my lord. Second question is, my lord, is that whether any point of time the accused person has said that this was taken under coercion, threat, and fear. In cross-examination also not taken. In 313 statement also they have not stated that it was taken on threat, fear, on coercion. I am coming to that, my lord, first.
No, he has denied. That question doesn't.
I am on Ahung Angsa, my lord. I am not on Manai Angsa.
He has denied. Ahom answer denied that there was.
No, my lord. I am coming, my lord. That is, your lordship kindly go to the evidence, my lord. Your lordship kindly first look to the, my lord, cross-examination of judicial magistrate first class, my lord. Yes. EP Kapo, page 30 to 33, my lord.
Page 30.
30 to 33, my lord. May I read that, my lord?
All right.
I am not reading all this, my lord. Content of the, my lord, statement has been proved by the judicial magistrate first class, my lord. They cannot say all the content has been proved before the court by the judicial magistrate. So far related to Ahung Angsa is concerned. I am not on Manai Angsa, my lord. That content I am not reading. The 31 last line, my lord. There are accused Ahung Angsa standing in the dock is identified by the witnesses. Exhibit 10 is the confessional statement of Ahung Angsa, recorded by me, and 10 AC are my signature. Exhibit 10 the thumb impression taken in my presence. Exhibit Manai Angsa 9 and XCDR. I am reading the cross part, my lord. Before recording the confessional statement, oath was administered, but the same was not recorded in writing. Important, my lord. Because 164.2 he is reading, my lord. First thing that they have retracted the confession. I am going to the whole material document available on the record. They never retracted the confession at any point of time, my lord. So far related to the Ahung Angsa is concerned, my lord. And second, 164.2 said that only explain the word legislature had used the word explain, my lord. I am coming later on, my lord. Before recording the confessional oath was administered, but same was not written in writing. I have made note regarding the statutory compliance in the confessional statement. Before recording of confessional statement, I have repeatedly asked whether he was confessing voluntarily. On being satisfied that confession made voluntarily by the accused, I proceeded the recording the statement. There are, my lord, other person, my lord, Nipen Das also come, my lord. What happened, my lord? Before 2 days of recording confessional statement, my lord, they were sent to the judicial custody, my lord. After 2 days, they were taken to this from the judicial custody, and they explained everything by the learned judicial magistrate. If you also go to the evidence, then Nipen Das said, I refuse to give confession. But he asked Ahung Angsa that whether you want to give the confession. He said, yes. Everything has been explained. And thereafter, confessional statement has been recorded, my lord. Yeah. I need not read the whole, my lord, statement. If you also go everything will come.
The prayer for recording confessional statement accused was by IO, not by accused. Accused Ahung Wangsa was arrested on 6 March 2019. And on the same day, he was produced before the court. I have remanded him to judicial custody. On 8 March 2019, prayer for recording confessional statement was received by me. On the same, I have recorded confessional statement by accused Ahung Wangsa. The confessional statement of Ahung was recorded after 2 days of judicial custody. That is important, madam. I have recorded the confessional statement in my chamber in presence of stenographer. Before recording the confessional statement, I have given reflection time for about 2 hours to the accused person. Again, given 2 hours time, my lord. There were no police personnel during the confessional statement of the accused. During that time, the accused was kept in a room in a court campus. Next question, my lord. Prosecutor Ahung Wangsa. The jail authority brought the accused person to court during the recording confessional statement. After receiving the prayer IO for recording the confessional statement, I have asked accused person as to whether they wish to confess. Accused Nipendas Kala initially confessed before me, but when I explained him regarding the consequence of recording confessional statement, then he refused to give confessional statement. No confession was recorded. He has explained everything. That is why one of the accused person might have has said, no, I have refused to give the confessional statement. He knows the consequences, my lord. Thereafter, it was recorded. Accused Ahung Wangsa voluntarily confessed even after explaining him regarding the consequence of recording confessional statement. Accordingly, I recorded his confessional statement. The application of recording accused statement was put before me during office hours. At 11, the accused person was brought to the jail authority. I have recorded the confessional statement on second half. Whether there any suggestion has been made from the defense side that this confessional was taken out of fear, coercion, and my lord, threat, my lord, that is not available. And that's why. Now let's kindly go to the 313 statement of the Ahung Wangsa.
Page number?
Page number 50. Question number 30, page 56, my lord.
Yes.
The IO stated that he arrested Nipen, admitted guilt, confessed the name of Ahung who committed IO, and again stated one Manai accompanying the accused person faithful. 164 statement recorded through Judicial Magistrate First Class Longding. On completion of investigation, he was submitted the charge sheet again. You other. I do not know about the same. He has not denied my. I do not know about the same and deny something different. In the next question, in the present case, you confess before Judicial Magistrate Longding that Nipen asked him to kill Anwaruddin jug, given a jug full of acid, asked to throw on the face of Anwar and run from the place. Nipen promised to next you have thrown the jug and thrown in the face of Anwar. What do I do not know about the same. He did not deny it. You have again confessed. Question number 32. Then Nipen gave mobile phone, you asked to call him Anwar treat the acid. Nipen, you asked call Longding, tell him that through acid Anwar has raped your girlfriend, and as per destroyed, you destroyed the SIM card and return your mobile phone to Nipen at his shop. I do not know. You confess. Next question here he has, Malad. It is not a fact, he said. The question is, Malad, next one important. The question number 34. The witness present in the exhibitor FIR, seizure memo, case CDR, SIM phone number, statement of Mana, confession statement of your sheet and seizure Nipen. Do you have anything to seize material? I do not know about the same.
So where is the retraction of the confession of Ahung Wangsa?
Well, that is not available on the record. He said, my lord, there is a retraction.
Where is the retraction? Mr. Chaudhary?
My lord.
Retraction of Ahung Wangsa's confession? Is it a retracted confession?
No, Mama.
There is no retraction.
No retraction.
Actually, he was arguing, Mr. Purkasta was arguing that's a retracted.
Yes, so it is the judgment also, it is written, it is.
It is the opinion of the court.
That's fine.
And I do not know, he has answer, I do not ever know about the same. You have the question is in the present case, you confessed before JMFC
Question number?
31, page 56. You confessed before JMFC Longding that Nipen asked him. So 31, 32, 33 confession. He says, I do not know about the same. He is not admitting I have confessed. And in 33 specifically says it is not a fact. If he does not admit, yes, I have confessed, and says I do not know about the confession, it amounts to retraction.
I do not know, my lord. And I'm submitting.
If it is my confession, I would sub.
All right, we'll see. Yes, let
Yes,
him
my
go.
lord. My humble submission before was as per example, my lord, in my lord, 5 days, when father called us, why you are swimming in Jurpukhuri, then we did not, I do not know, that does not mean, my lord, I have denied. If I denied, he said, this is a false statement, and I denied this statement. That is not available. 313, he should categorically state, then they denied the statement. And in cross-examination part also, he should deny. That is not available. Second thing is that, my lord, your lordship kindly go to the evidence of PW8. And then another question, question number 36. Do you have anything to say? 35, 36, my lord, on that, my lord. Do you have anything more to say in this case? I do not have anything to say. If he has an explanation, he should, my lord, explain before the court. I was tortured by the police, and on the tortured, my lord, they have taken my statement on coercion threat. My lord, that is not available, my lord, in the case.
So was it put to the victim, to the accused?
Yes, ma'am.
Was any question put to him on based on Exhibit 10?
Yes, ma'am.
And if so, where is it? Where is Exhibit 10?
Yes, my lord. Question number 30, my lord.
Question number 30.
Yes, my lord. The IO arrested and confessed the name of Ahung and Puman was confirmed. IO has stated the Mongol company, and his 161 statement was recorded through JBMC Longding. On the completion of investigation, he has submitted the charges against you. I do not know about the same. 56, my lord. Asking about 164 statement, he said nothing. Ahung.
Where is the statement about court witness number 1?
Yes,
To the accused.
that is important.
CW1.
Page 30, my lord.
No. In the 313 of the.
It's not there. No
Huh?
question about that.
What's happening here? What's happening? They have stated about the confession, my lord. In respect of CW. CW.
That is question 31, it seems.
Yes, my lord. That question of 31. And another thing is that, my lord. Oh,
Yes.
Yes, my lord. That, my lord, if your lordship go to the, my lord, 164 statement of Ahung Wangsa, and if your lordship go to the medical report, my lord, it is corroborated to each other, my lord. I am coming, my lord, because, and there is no suggestion has been made, my lord, This was not that your lordship kindly go to the evidence of PW6, my lord.
But before that, we'll just go back once. The confessional statement of Ahom Wangsa. Where is,
Yes,
which
ma'am.
page is it?
One, my lord,
124.
124.
Mr. Chaudhary, if you want to say anything more, we'll come back to you. Just having a preliminary peek into what will be answer to these questions.
164 CRPC. The form for recording confessional statement.
Yes.
This is from my lord.
Yes.
The accused Ahom Wangsa is brought from judicial custody Longding UTP cell before me at Judicial Magistrate First Class Court Longding on 8/3/2019 at 11:30 AM to record his confessional statement. I have asserted the offense was committed at Longding at 3/2/2019. The accused person is placed in charge of court official for 2 hours. I have satisfied myself there is no police officer in the court or in place when the proceeding can be seen heard. Record my statement. My name is Ahom Wangsa. My father's name is Sonju. Whether you married or not, no. Whether your source of income survival, no. Do you know I am not a police person but a magistrate? Yes. Whether police or any other force you to confess before the magistrate? No. That is important. Oh. Question number 5, my lord. Then, why do you want to confess? I want to tell the truth, what I did. Do you know that you are not bound to confess? Yes. Then the statement I read, my lord. What do you want to confess? Question has been put. Then he gives answer. On 3/2/2019 at about 3:04 PM, Sri Nipen Das Kala asked me to kill Anwar by dao. That is Anwar ko khatam kar do. Upon which I
Khatam kar do.
Upon which I asked him, why then Kala said that whenever he used to go to the institute for taking stuff for his mobile shop, then Anwar used to block him and take his stuff like mobile and its accessories. I said we would not be able to kill him by now. Then Kala said, Kala means Nipen, my lord, he will give me an easy way to kill Anwar. Then he went to his house, brought one jug full of some liquid acid and give it to me and asked me to throw it on the face of Anwar. Ran from the scene. Thereafter, 10,000 rupees in the next. Accordingly, I took the jug acid and threw it to the face of Anwar and ran from the scene. Medical evidence corroborated it, my lord. If you all go to the medical evidence, photograph exhibited, my lord, which was not, my lord, denied by the defense side, my lord, not objected by the defense side, shows all these things, my lord. After one day, Kala called me, asked me to come to his house. When I reached his house, Kala gave me a mobile phone number with SIM card and asked me to call Anwar. Tell him that acids were thrown to his face because Anwar had raped his girlfriend, Ahom girlfriend, and then Kala also asked me to call Superintendent of Police Longding and tell him that I threw acid on the face of Anwar because Anwar has raped my girlfriend. Thereafter, Kala told me he has designed all the conspiracy, designed all the crime, my lord, and as per his instruction, he is doing all these things. 164 stated he is voluntarily stated before the, my lord, before the, my lord, magistrate, my lord. I threw acid first Edward because Anwar raped. Thereafter, Kala told me to destroy the SIM card by seeing it. Accordingly, calling Anwar SP Longding, I destroyed the SIM by seeing. Thereafter, I returned mobile used for calling Anwar SP Longding to Kala at his shop. After 4 or 5 days of the incident, I and Puman went to the house of Anwar and asked money, but he gave only one phone, Redmi 16A mobile phone amounting to rupees 6,000 only, and denied to give us any money. Thereafter, we took mobile phone and went to our house. Next day, I went to Fungsu and Puman went to Khumsa, and from there, I being arrested and brought to Longding. This is the confessional statement, my lord. He has also promised to give money, but money was not given, one mobile phone was given. Then next, my lord, Pisca memorandum. This is Pisca. I have examined the Ahung Wangsa that he is not bound to make a confession. If he does so, any confession, it may be used as evidence against him, and I believe this
Just 1 minute, just 1 minute.
what 164.2 is said.
It is there that if he gives evidence, it will be used against him.
I have examined. My question is examined. It is to be explained. The mandatory requirement as per section 164, subsection 4, quote unquote, it has been written, explained.
164.2 said it should be explained. What legislature used the word explain, my lord. It may be used evidence against him. I believe this confession of voluntary. It was taken in my present hearing, read over the person making it, admitted by him to be correct, full and correct statement in him. Brief statement registered reason for believing that the statement was voluntarily made. Accused was produced, that is important. 8/3/2019, 11:30 AM for recording his confessional statement for judicial jail Longding. He was produced from jail, my lord. I asked whether he is willing to confess or not, on which he said he is willing to confess. Therefore, accused was taken under the court official 2 hours to enable him to refresh. After 2 hours, again asked me, accused is willing to confess or not. He answered positive. The statement recorded, the accused is forwarded to judicial custody. After the recording confessional statement, my lord, he was sent to the judicial custody, my lord. He was not sent to the police custody, my lord. And he was taken from the judicial custody. After 2 days in the judicial custody, 2 persons were produced. One is refused, Nipen Das, and Ahung answered this 164 statement. And whole while of cross-examination party of the lordship, sir, they have not any question that this confession has been made under threat, fear, or my lord, coercion. This is important, my lord. I want judgment I shall produce before your lordship. That is why I am saying all these things, my lord. This is the evidence before. Then, my lord, as I complete my lord 164 statement judgment, my lord, thereafter I come to PW8 statement. 2020. One thing is available in the order. My order that the court has stated that I satisfied, and thereafter order has been passed for conviction. Yes, but that is available on the record, ma'am.
Is it disturbing you? He doesn't. Mr. Ahmed, you will also make your submissions.
Yes, sir, he is assisting. 2025 SSC 782, my lord. Quorum is 3 judges, my lord.
Acha, Mr. Chaudhary, was there anything else you wanted to argue, or factual part he has covered?
Factual part already he has covered, man.
Okay.
782.
So we'll give you a chance to reply, make a reply, and in that you cover everything, whatever is there.
2025 SSC 782. My lord, I have another copy of the judgment also. Huh? Yes. Yes, my lord. Oh, sorry. Two 2025 SSC 782.
Just a minute, just a minute.
something it book list di dia Abdul Qadir di dia 2020 next year 2024 is the timeline itu di boleh
Yes,
Yes, my lord.
yes.
Lordship, kindly look to the para 22.
Para 22.
Yes, my lord. Page 793. My lord, first, my lord, I say, my lord, quorum is 3 judges, my lord.
Yes.
Rohinton, Falinariman, Sanjeev Khanna, Sujjokan. 3 judges, my lord, quorum. Quorum is important in the case, my lord, because official liquid to the if someone has produced 2 judges judgment, my lord, 3 judges judgment will prevail. The argument for the petitioner began with challenge to reliance by the court on confessional statement of the accused. Mr. Luther strenuously contended that strict compliance with the safeguard for recording a confessional statement as mandated under section 164 are mandatory. As rule Sibappa, he strongly disputed admissibility of the confessional statement made by the petitioner before a magistrate on 2011 to 2010 on the premier. 22:1, my lord. Confession was coerced and involuntarily in contravention of section 162 CRPC and section 24 of Indian Evidence Act. My lord, this defense was taken, my lord, later stage, my lord. The petitioner had been physically assaulted by the police whilst in custody as evidence to answer to question number 8 posed by magistrate during preliminary examination 1911-2010. Second, the petitioner under severe psychological stress owing to in custody killing of co-accused. And third, circumstances surrounding the confession were suspicious. For the IO move an application stating the petitioner it was ready for volunteer and confession. He was in judicial custody, not in police custody. The magistrate failed to comply mandatory prescription success since he did not inform that he would not be sent to police custody and recording the confessional statement. In our case, judicial custody he was taken and confessional was, after giving the confessional statement, he was sent to the judicial custody. In the light of human attempt assailing the confessional statement of being non-voluntary and violative of right granted under Article 23 of the Constitution, it is an alternate reliance for having retracted by the petitioner. It may briefly notice that a conjoint reading of confessional statement comprising of section 163 and 24 Indian Evidence Act constitute a canteen of decision of the court. It is obvious that even in the absence in express of provision retracting confessional statement, one may court have preferred a rule of prudence, whereby in case of dictation, court reduce the probative value of such confessory statements. In our case, my lord, there is no, my lord, retraction, my lord. My lord, he has never stated before the, my lord, either before cross-examination or 330 that this confession was taken by threat, etc., my lord. Then test 24, my lord.
But was the accused informed that he will not be sent to police custody if
My
he
lord.
does not make a confession?
I read again, my lord. Then, my lord, your lordship kindly come to me, my lord. Page 26, my lord. 2.
Page or para?
26:1, para 26.1. During, yes, my lord, have you also got it?
Yes.
26, my lord, first 26, my lord. From the chronological analysis of confessional statement of the petitioner dated 10/20/11/2020, as well as the preliminary examination held on 19/11/2020, it is apparent that learned magistrate so and so duly complied with all procedural requirements for recording confessional statement, affirmatively satisfy him of the voluntariness of the petitioner's confession. He satisfied, my lord. My lord, satisfy himself. The magistrate's satisfaction is necessary, my lord, of the voluntariness of the petitioner's confession, because he is the best person to know. During preliminary examination, the petitioner informed the magistrate he was brought from Central Jail, Coimbatore, on 19/11/2000, hence bridging the possibility of any coercion or influence by the police. In our case also produced from the judicial custody. Further, a perusal of the record shows the petitioner last in police custody on 11/11/2020. And hence
Not
there is,
2010. 2010, not
oh,
2010.
sorry, my lord.
Hmm.
2010. And hence there is no doubt that he had been in judicial custody for some time prior of giving confession statement. That is important, my lord. Hence, as per Abdul Razak Murtuza, Dafida versus State of Maharashtra, it can be inferred that he was not under influence of any investigating agency. In reply to question number 8 during preliminary examination on 19/11, when asked magistrate whether someone tortured him, the petitioner does say he was beaten by the police. However, when asked whether police tortured or compelled you to give statement like this, the petitioner denied any such torture or compulsion. In my case, nothing is available, my lord, when question has been asked. Similarly, when the magistrate asked him whether he was told some sweet word, such as the confession statement will be beneficial with threatened by police or by anybody else, if statement was not given, the speaker basically denies the same. He also acknowledged the fact that he was not under compulsion, give a confession statement, that he was aware of the fact that statement could be used against him. Here also my available, my explanation of the magistrate that is available. My. Further, when requestioned by the magistrate if the petitioner was tortured, he answered in the negative. He does not only was the petitioner inconsistent in his claim, but further it is evident that the alleged physical assault by the police, if at all, would be committed week before the confession. Vague and passing claim police assault supposedly committed far confessional death cannot be done holding confession as coerced. After preliminary questioning on 19/11/2010, the petitioner entrusted to the prison warden sent back to the judicial custody for reflection after duly informed that he was not under obligation to give confession statement. Thereafter, he reported before the magistrate on next day 2 p.m. but even the opponent to change in mind, not confess. The magistrate once more satisfied himself of the voluntariness of the petitioner and absence of the police influence. And it is clear as that adequate opportunity to rescind provided and magistrate entrusted that any possible lingering effect of alleged beating, psychological stress post of encounter of the co-accused would have been mitigated. It is also apparent that the magistrate duly informed the petitioner about the repercussion of his confessional statement and made no false assurance in helping the case as had made in state of Maharashtra and Rabindranath Guha. It was 1981 to 82 Criminal Law Journal 216, and erroneously been relied upon by the Lutha. The statements once recorded was thereafter read out to the petitioner, who signed it to be correct. Here also he put the thumb impression. The magistrate signed the statement 4:30 p.m. and afterwards sent to the petitioner judicial custody. The magistrate thus fully conscious his statutory obligation factually entrusted the petitioner was sent to the police custody. Post the confessional statement, it was further clear that petitioner was kept in judicial custody for almost 20 months after the confession over the course of which there was no likelihood of being entrusted to the police. Till no potential attempt has been detected, confession was made by him. They are in the same case, madam. He was in judicial custody. He never detected the confession. Till the, my lord, appeal has been filed before this court, my lord. Further, it is essential to note that petitioner put forth any protest confession despite a multiple opportunity during the course of trial. That is import 27, my lord. This court held earlier as Shankaria versus State of Rajasthan. The retraction must be made by the accused as soon as possible. Otherwise, there would be strong presumption of voluntariness in the confession. That is important, my lord. The confession in the present case was not challenged during stage of the 20th. The confession in the present case was not challenged during the stage of framing charge over the course of exam 47 prosecution witness but instead only partly disputed through a letter written in a secret just before the petitioner examination under section 313 of the code. Before 313, he made an application, my lord, that it was taken on coercion, my lord. It is thus evident that such rejection at the fag end of the trial was not natural, but rather meticulously formulated, perhaps as per defense strategy. Hence, there is no doubt about the voluntariness of the confession 2011-2020, or it being unaffected by subsequent rejection. Next, that apart, even if confession 2011-2010 were to be treated of being retracted by letter dated 25/7 examination as adopted during the examination of 313 of the court, till the original confession can be relied upon and coupled with corroborating evidence, conviction can be secured on the stand of such confession. The rule regarding use of retracted confession was noted by this court in Subramata Gaundan versus State of Maharaja, as well as 4 judges of this bench in Pierilal Bhargava was stated holding that a retracted confession may in the legal basis may form the legal basis of conviction if the court satisfied that it was true and voluntarily made. It was 4 judges judgment, my lord. But it has been held that court will launch based on conviction on such a confession and corroboration. It is not ruled that, but is only a rule of prudence. It cannot be even laid down as inflexible rule practice. Prudence, no circumstances such as conviction can be made without corroboration for a court particular case. Then paragraph 30. Till further, it is clear that even in the retraction of statement, the petitioner had made substantial admission, which read together the prosecution evidence are sufficient to convict him. Though the letter dated 25/7 to the petitioner merely restated his conviction with certain omission and a few denial as compared to his earlier statement, although he agreed to be the place of occurrence that the Mousakami throughout the incident, instead of admitting an equal role of commission of rape and murder, he portrayed himself to helpless bias and standard. The petitioner has attempted to justify retract saying that he hold the truth magistrate upon his statement not dream. Hence, the magistrate affirmation 164 is incorrect. A comparison retraction confession 2011 had shows that merely an improvement. The petitioner admitted all general circumstances incident having been present since all crime being trained, co-accused, and offense as claimed by the prosecution to have occurred. However, he merely contended the crime were committed by the accused, not by the petitioner. Regardless thereto, there is sufficient internal omission. Moreover, we must note that petitioner has not been convicted by the court below solely on the confessional statement under 164 confession corroborated by enough evidence. It will stress that even independent of circumstances, this court would nevertheless is harmful will to the accused person. There are some independent witness he has convicted. My humble submission before your lordship is that, my lord, if your lordship goes to the medical evidence, well, it is clearly corroborated with the confessional statement. First, my lord, your lordship kindly look to the statement of doctor, my lord. PW8, PW6, no.
PW10.
PW10, my lord. Page, my lord, 28. It is small, my lord. The deposition so and so oath, man. Page 20. Have you also got it, man?
Yes, please.
That, my lord.
Page 28.
On 3/2/2020, I was posted at CSC Longdin, EMO. On that day, about 6 p.m., 7 number of injured person came to do hospital treatment. They are Anwaruddin, Akhtaruddin, Khila Rongrang, Nawang Rongrang, Santosh Das, Mona Das, Rajibur Rahman. They had complained that they sustained burning injury allegedly causing acidic substance. The word acidic substance. One thing is that my learned friend is doing wrong, my lord. 326A said, my lord, acid, etc. And if you also go to the acid or any of the like substance, what is or? Disjunctive word, my lord, independently said, my lord.
We'll read
So,
it. We'll read it.
yes, ma'am. My lord, on examination, I found Anwaruddin sustained third-degree burn injury on the face, upper arm, neck. This was corneal damage of the patient. The type of injury was grievous. I referred to the higher medical treatment. It is the third-degree burn injury, my lord, on his face, my lord. Upper arm and neck, my lord. And there is corneal damage also, my lord. This is, my lord, if you look at the photograph, my lord, that is similar to that injury, my lord. On my examiner, I found that Akhtaruddin sustained 3-degree burn injury on both lower extremities leg. The type of injury was grievous. I referred him for higher medical treatment. Other are simple injury. Then my lord, your lordship, come to the cross-exam. I cannot say the injury. The patient can then say the injury was caused by diluted. The injury sustained patient may also be caused by throwing boiling water. Here, my lord, any suggestion has been made that this third-degree burn injury is not available here. No suggestion has been made. They only said that patient come and say injury caused by dilute acid. The injury sustained. The word is may also be caused by boiling. May, my lord. But what is affirmatively the injury caused by dilute acid? Dilute acid. T20, if it is assuming but not admitting T26A available, if boiling water is available, then T26A is attracted, my lord. The what etc. has or any other substance. May I read, my lord? Before going T26A.
Any other means?
Voluntarily causing hurt by use of acid, etc. Have you got it? Whoever causes permanent or peripheral damage,
Not
or
peritoneal, partial damage.
partial damage or deformity to, or burn, or maims, or disfigures or disable any part or parts of the body of a person, or causes grievous hurt by throwing acid, or by administering acid to the person, or by using any other means. What is using any other means? With intention to causing, or with the knowledge that he is likely to cause such injury or hurt, shall be punished imprisonment for either description for a term which shall not be less than 10 years, but which may extend for life. And paragraph 95 of the paragraph
Yes.
50th, page 95, that was discussed.
Yes. Page?
Page 95, paragraph 58.
All right.
For attacking T26A, it has to be proved that injury was caused by victim any one 8 type of injuries: permanent damage, partial damage, deformity, burning, maiming, disfigurement, disability, grievous hurt. Section 20 IPC provide definition grievous hurt. It was provided grievous hurt. The following kind of hurt are designated as grievous. First, emasculation. Secondly, permanent privatation of the sight, either eye. Permanent, thirdly, permanent hearing of either ear. Fourthly, privatation of any member of the joint. Fifthly, destruction of permanent impairing of the power of any member of joint. Sixth, permanent, this is important. Permanent disfiguration of the head or face. 6. Seventhly, fracture or dislocation bone. Eighthly, any hurt and endanger life which causes to suffer to be during space 20 days, bodily pain, unable to follow his ordinary pursuit. That was discussed, my lord. And this is similar injury has been got by them, my lord. And 15 and 16, my lord, may I read, my lord? I have perused the all injury report of the victim person who were issued by TW10 after their examination. It is reflected that the injury sustained by victim Anwaruddin and Akhtaruddin are third-degree burn injury are grievous in nature. Accordingly, they were referred for the higher medical treatment. Where the injuries sustained by the other victim or minor burn, I have also produced 13 number of photographs of the victim Anwaruddin and Akhtaruddin are exhibited exhibit 12 series. These photographs are so weird that one has to have courage to see them. The photograph is available by exhibit 12, and the photograph was not denied by him, my lord. When he was cross-examined, he has denied this photograph is there, my lord, tampered. Nothing question has been put. Victim Anwaruddin has sustained burn injury on his head, face, neck, chest, disfiguring his body, deforming his facial appearance. When PW8, victim Anwaruddin was examined before the court on 16/11/2019, after more than 9 months of the incident, the injury was disfiguring his appearance was visible on his person. PW8 victim has stayed at ICU for several months, and he has undergone 3 plastic surgery for restoring his physical appearance. But even after plastic surgeries and treatment, his appearance was deformed even after 9 months of the incident. As provided they should have taken a certificate. But what the learned court said, PW5 had stated in his evidence that he got a call. He recorded he had the recordings. Then he had transferred it to a CD, and he had no animosity with the accused or accused. So the trial court said there is nothing to disbelieve PW5, and on that basis it went. But yes, it was not produced,
So why
and it was written.
why it was not produced? The court would like to know that.
Yes, court asked, and the PP said, of course, the trial court asked, PP said that because 65B certificate was not procured, so it was
CDR. That is only for the CDR.
only for the CDR, call
But for the
details.
CD, that
What about the voice sample?
Voice sample, voice was recognized by PW5, voice recognition is also there.
it is just said that PW4, who is the brother,
Huh.
he said that why will he not recognize his brother's voice? That is the only thing.
That is the only thing.
Recording that was made
Displayed.
to listen to.
All right, we'll have it on next Tuesday. In the meantime, you collect the name of the IO, etc.
IO, I've collected the name. He is Borua. I've seen the name, and he has now retired. 2 years back, he retired. Now he's staying at Tejpur. Pradip Borua.
Pradip Kumar Borua.
Pradip Kumar Borua. He retired as a border commandant from the Assam Police, something. Now he's in Tejpur. I spoke to him. He said, by the way, I don't remember, that what I did and all. SP, of course, SP Nogam is there. He said that anytime he'll come if your lordship wants. This is what. But yes, there is flaw, there is
We'll have it on Tuesday, have a closer look and then we'll see
lordship.
what order is to go. Heard Mr. D.K. Bhattacharya, learned counsel for the applicant. Also heard Miss S. Chan, learned APP Assam appearing for the state, and Miss
Ms. Ardas, for respondent number 2.
Ms. Ardas appearing for the respondent number 2. On the request of the applicant's counsel, this matter is directed to be posted again on the 13/2/2022 for necessary orders. List accordingly. You file in the meantime, whatever
Yes.
you want to file.
Obliged.
If you can look up some law on this point
Hmm.
about the appellate court. Can the appellate court look into this matter, ask why the investigation was not done, trial was not done in a particular manner? Just check it up and tell us. Please.
Obliged.
Please, your lordship. Lordship, for daily list, item number 12, I want to mention for parts of the matter.
Item number 12 is a hearing, Ms. Manjit Sarkar.
Today, he's for hearing in days.
Today's,
What do you want?
Adjourn for the day because I am suffering from illness.
On the prayer of learned counsel for the appellant, the matter stands adjourned for the day. Yes.
Regarding the confessional statement under section 164 CRPC, my lord, I am relying one judgment passed by this honorable court, my lord, Ashwini Kolita versus State of Assam, my lord. In that case, my lord, I rely on paragraph, my lord.
Yes.
I asked one of the lawyer, my lord, who was appearing. He said one appeal has been filed before the apex court that was dismissed.
It was
G. Talukdar told me, my lord.
Another appeal is pending. No.
I will
The
answer.
appeal file has been dismissed.
That was dismissed. He told me.
Okay.
Paragraph 48, my lord, of that particular judgment, my lord. On careful reading of the aforesaid statement of the accused Ashwini Kolita, we find that the accused has a given detailed account not only his relationship with the deceased, but also how he had spent previous night in the house of Preeti, taking advantage absence of her husband who had gone, how they decided to meet Hotel Sagar. He also stated as to how.
You're reading from which paragraph?
Paragraph 48, my lord.
48. Okay. Yes, please proceed.
Yes, madam. He also stated how on the day occurrence, Shankar Vishwakarma had shown to his room number 105 and how he had hidden the naked body of the victim under the bed only to save the skin, and thereafter went out to room 105 to procure some liquor. How he had removed the cloth so and so, cut her hair, then went to the house of his elder sister. He also stated how the clothed hair of so and so were hidden by him inside a dry well near the house of the sister. He had let the pros show them he had confessed the guilt. The statement appeared to be consistent with the disclosure statement exhibit 20 to find due corroboration from the evidence available on record. In other all factual details emerging from the confessional statement of the accused, Ashwini appeared to be correct, also substantially borne out from the material available on record. The only fact which that accused did not admit in specific terms is that he had murdered so and so inside the Sagar room number 10 strangulating her, although he has indirectly admitted the same by saying that he has admitted his guilt. In the above context, we are pertinent to note herein that names para 50, your lordship. As noticed above in statement recorded under 164 CRPC, accused Ashwini has discussed all other relevant facts, but had carefully avoiding admitting a specific term that he killed deceased. In other words, accused Ashwini in a statement recorded 165 substantially admitted all relevant facts, which, when viewed in the light of the evidence available in the record, would constitute an offense, support the prosecution theory. Therefore, we are unable to agree with the supposition of Mr. So-and-so that the confessional statement contained only an exculpatory statement. Even if it is held confession of accused Oshini Kolita contain both exculpatory and inculpatory statement, in that view, the apex of Nishikant, Ja, Supra, and co, we find hope submission of learned APP to permissible for the court to segregate the explanatory part from the confessional statement, act only on the part of the statement. Then you'll also come to paragraph 54. Coming to the next question as to whether Page 54, my lord. Coming to the next question as to whether confessional statement of the accused person had been recorded in accordance with the provision of law. If so, whether the learned trial court had committed an error in placing reliance on their confessional statement by ignoring their retraction. It is not to be noted that evidence of PW4, it has come out, all the accused person has sufficiently questioned about the consequence of their confession, which was exactly done in the instant case. Notwithstanding the same, when they insisted on recording the statement, the accused person was sent to the office chamber for the reflection under watch of her peon. Same thing has been done, my guess. The PW4 has also deposed that during the time police personnel was allowed inside her chamber after giving 4 hours time reflection, despite of being warned about the consequences. When the person still wanted to record the statement, it was only when their statement was recorded by her, being satisfied that accused person were willing to make their confession statement voluntarily. Then your lordship come to the matter, page 66, man. Paragraph 66, man. The next question pertains to the failure on the part of the learned to put question to the accused as to why they wanted to make a confession. In the present case, it appears from the evidence from record that PW4 had not specifically asked the question why they wanted to make confession. However, it is also apparent material on the record. Accused person was sufficiently warned the consequences, but despite the same has willingness to record their confession statement. The learned magistrate was satisfied the accused person was voluntarily willing to record the confession. We do not find any justification ground to correctness of satisfaction of the magistrate. In my case also 164 statement, magistrate has said, I satisfied. His satisfaction has been shown by an express my lord, word, my lord, by expressing the word. After recording the statement, accused person was sent to judicial custody. There was material corroboration confession, the accused person, other available record, therefore, truthfulness of the confessional statement is well established. We also find all other procedural requirements laid down 164 statement have been properly complied while recording the statement accused person. After going through the material available, no doubt arises the truthfulness of the confession. Moreover, the appellant counsel also not able to show any prejudice being caused to the accused person due to failure on the part of PW4 to put a question accused why they wanted to record their confession. Here in the instance, they have not showed any prejudice. They should show the prejudice. This question was not put, that is why I am prejudiced. In view of the above, we are opinion that having regard to the facts and circumstances, mere failure on the part of the PW4 to put a question accused why they wanted to record statement by itself not having vitiating effect of the interim order. Then your lordship kindly go to page paragraph 71. 68, my lord. 68, 63. I'm reading all these things. Coming into the next issue regarding the reliance placed on the detected confession accused person, what would be significant note herein that accused person have not denied having made the confession before the magistrate. As reflected exhibit 578, but their stand statement recorded due to torture pressure from the police. The retraction has also come while examining the accused 313 CRPC, and that too after 10 years from the date when the same was recorded, although the accused person had all the time confession accused yet to decide. Same thing has been said, my lord, in 2020 judgment, my lord. That she doesn't just I have produced before the court. Same thing has been said. 60. Law is 70, my lord, paragraph. The appeals court held that the burden of proof the confession was obtained by threat, duress, and promise on the accused. It is the part of the accused to show there is a threat and there is a duress, my lord. That is not available in the instant case, my lord. The above law has been reiterated by K.L. Punai Supra, 71 paragraph. In the Rajenboro state of Assam, this court has observed that it is not the requirement of law that one confession was retracted. The court should presume the confession was tainted. It was further observed that not retracted confession was a rarity ingredient. To retract from the confession was the right of the confessor accused against whom confession was produced was invariably exercised the right, but it be injudicious and repetition of judicial confession on the mere premise that maker has retracted it. The court duty evaluate evidence concerning the confession looking into all aspects. My humble submission before your lordship is that when 313 that question was put in respect of 160, he has not denied. He said, I do not know. That is not my denial, my lord. So, my lord, then your lordship, 79 and 80, my lord. That confessional statement made as per evidences act of section 30 and section 10 can be used against the other accused person on the same transaction, my lord, same trial, same transaction, same FIR, my lord. In case of Nolini Supra, Honorable Supra, section 30 evidence, while dealing with the postulate of section 30, the Supreme Court made the following observations in para 6, which is reproduced below. A plain reading of section 30 of the evidence discloses the following condition exists, namely more person than one and are being tried jointly. 2, the joint trial of the person is or the same offense. Confession is made on such persons who are being tried jointly on the same offense. Such confessional effect made as well as person who are being tried jointly of the same offense. Such confession is proved in the court that may take into consideration confession maker thereof as well as all the accused person. Here, my lord, joint trial is going on, my lord. From the one affair, one incident, my lord, both the person has, my lord, faced the trial, my lord. So my humble submission before your lord, as per section 30 or section 10 of the evidence, the confessional statement made by the co-accused can be used to the other accused persons also, my lord. Then your lordship, one judgment, my lord, of this honorable court, 2021 4 GLP 590, in respect of section 145 of Evidence Act. Because, my lord, my humble submission before your lordship, if your lordship go to the, my lord, cross-examination part, 313 part, they are not denied. The what has been, my lord, evidence adduced by the, my lord, prosecution witnesses. To that aspect, my lord, lordship kindly come to the para 45, my lord. 44, my lord. Inner page, my lord, same. Have you lordship got it?
Yes, yes.
By relying on several judicial pronouncement on the issue, learned trial court has rejected such a plea. Learned defense counsel on the ground that defense side has failed to prove the contradiction of the witness in accordance with law. Let us now examine the validity of conclusion recorded by the learned trial court, my lord. Then your lordship come to the, my lord, 145 has been discussed, my lord, in paragraph 45, 47. In case of V.K. Mishra, another aspect of 2015 9 SCC, the Honorable Supreme Court had occasion to consider the correct manner of proving contradiction as to the previous statement made by witness. Ample interpretation of section 145 of Evidence Act. The following observation have been made by the Supreme Court in paragraph 19 of the aforesaid as follows. Under section 145 Evidence Act, when it is intended to contradict the witnesses by his previous statement reduced into writing, his intention of such that witness must be called to those parts or which are used for the purpose of contradicting him before the writing can be used. While recording the deposition of witness, it becomes duty of the trial court to ensure the police statement in which intent to contradict is brought notice of the examination by reproducing it. If the witness admit the part of intended to contradict him, it stands proof, and there is no need for further proof of contradiction. It will be read while appreciating the evidence. If we deny having made on that part of the contradiction is merely brought on record, but is yet to be proved. Thereafter, when the investigator was examined in the court, his attention should be drawn to the passage marked for the purpose of contradiction. It will be then proved in the deposition of investigating officer, who again by referring police statement will depose about the witness having made to the statement. The process again involves referring the police statement, calling out on the other part who is the maker of the statement or intent to be contradicted. If the witnesses was not comforted with the part of statement which the defense wanted to contradict him, then court cannot so moto make use statement police not proof in compliance of section 145 of Evidence Act, my lord. Then your lordship come to the, my lord, paragraph, my lord, 48 and 49. In the instant we find that defense counsel have failed to invite the attention of the witnesses, PW 1, 2, 3, 4, 6, and 9, as to the previous statement in writing so as to contradict the witness. Once the contrary attempt has been made to prove such contrary through the IO in the manner indicated above, having regard to the ratio laid down in case of V.K. Mishra and Khanakanta Das Supra, we are viewed that the learned trial court has correct in holding the defense side had failed to prove the contradiction in the statement made by the prosecution as per requirement, therefore could not be permitted to avail benefits such as if any testimony of the prosecution is made. In so far, omission and discrepancies in the testimony of prosecutors are concerned, law is well said by means of long line of judicial punishment, the minor contradiction and discrepancies in the testimony witness would not have fatal bearing the prosecution case unless the same goes into the root into matter. In case of Ramappa, Halappa, Pujar, and others, Supra, the Honorable Supreme Court has observed that there can be some contradiction in the deposition of witness. This is minor variation from the earlier statement, but necessary. Again, the case of Mustaq and Kanya Supra observed discrepancy if it's ignored. So, my lord, you're looking at paragraph 53, my lord. Applying the ratio law laid down in Supreme Court in the decision, whatever, we are therefore the view that the basic story of the as regard the time and place of occurrence, the presence of assailant at the place of occurrence, the previous rivalry constitute a motive of the crime, and homicidal death of the deceased, family established cogent evidence on record. The sole exception is that there is no evidence to establish accused Abdul Qadir Ghani, in fact, joined the unlawful and commit the murder of the. This is inconsistent, improvement, embellishment in the testimony of the examined by the prosecution side. However, we do not go to the root of the matter of the prosecution. Moreover, as noted above, defense has also failed to prove the contradiction in the evidence adduced by the prosecution witness in accordance with law. However, we are agreement with view expressed by the learned trial court. Evidence would be contradiction as per law. Now, your lordship kindly go to the evidence of Ahung Wangsa, PW8.
PW8 is Ahung Wangsa.
Sorry, Anwar, sorry. Anwar,
He is the victim.
he is a victim, my lord.
Yes.
It started from page 21, my lord. And page 22, my lord. I am reading, my lord. First paragraph, my lord.
Yes.
On the particular date of the incident, I was at my shop. During that time, accused Pumom come to my shop for demanding one tempered glass of mobile. My shop is vertical shape and I was backside of the shop. On demand of the tempered glass, I took one tempered glass, came into the front of the shop and tempered glass to Puman. During that time, Puman has also told me he does not want the tempered glass given by me. During that, the accused Ahung, who was standing there covering his face by some scarf, has thrown acid to me. Then he gives explanation. I know Ahung Wangsa as he used to work at the shop of Nipendas, and sometimes he used to bring customer my shop, and I used to give commission. On the time of incident, I recognize Ahung Wangsa wearing apparel and body language, even though his face is covered. This is the identification of Ahung Wangsa. How he recognized the Ahung Wangsa? I know a man, my lord. He covered his face. He usually come to my chamber, my lord, frequently. If he come, my lord, from the body language, I can recognize that person. There is no that you can only recognize from the face. Where is that law? And when he cross-examined the Ahung Wangsa, he my page 24, my lord. Last two line, my lord. Cross-examination of Ahung Wangsa and Puman Wangsa, my lord. It is not the fact that I have before the last part 3, my lord, before the incident, accused come once covering his face from his body language, I could make out that Ahung Wangsa, my lord. And my lord, in cross-examination, my lord, this part was not denied. The first part we had mentioned, and other way, my lord, rather, it was, my lord, confirmed in cross-examination, my lord. There are two ways, my lord, he has, my lord, identified the accused persons, my lord. One part is that, my lord, from body language and known to each other from long time, my lord, he recognized the person. And another in cross-examination of Nipenda said, from CCTV footage, I could recognize the Ahung Wangsa. But that was not available. And in the cross-examination of IO, he has stated that, my lord, that there is no CCTV available. One CCTV Nipen does, but on that day CCTV was, my lord, closed, my lord. That's Anwaruddin has said, my lord. And one part, my lord, page 24, important. Exhibit 12, a photograph showing my injury and my brothers. That was not in cross-examination, my lord. They have never said that this photograph is false and fabricated. They have to put the question that this is forged and fabricated. But that was not available in the instant case, my lord. And my lord, your lordship, kindly go to the, my lord, PW, my lord, 7, my lord, Jamsong Wangsa, my lord. What he has stated, my lord, one thing that she material forwarded to FSL for expert which is yet to receive. That was not received, my lord. And in respect of phone number, my lord, he has in cross-examination stated that first line, returning code made from 676808600421, having IAM in ambassador. The person is unknown as per investigation. Accused Ahung Wangsa has thrown acid. Two accused person were at the place. Another is looking sir. Witness Manu Wangsa disclosed. I am not going to the Manu Wangsa. I am only, my lord, my humble submission before also on the basis of Ahung Wangsa. Yeah, Ahung Wangsa and my lord, this person's, my lord, Anwaruddin statement corroborated each other, my lord. He will explain some part of the Anwaruddin statement, he told me, my lord, in his argument, my lord. So considering this aspect of the matter, my lord, as per 164 statement and medical evidence, medical report was not comforted. 164 statement was not, they are not comforted by them. And my lord, PWH statement, which has been mentioned here, was not contradicted by them, my lord. So considering this aspect, my lord, this appeal is liable to be dismissed by this honorable court, my lord.
Already my learned friend has said the facts, lordship, so I'm not going into the facts of the case, but your lordship may kindly just turn to page 18, that is the evidence of the IO. Here I'm relying on one line, lordship, from top, 1, 2, 3, 4, 5, 6. 7th line from top, lordship, page 18.
I have obtained the CDR of the phone with IMEI number from which the threatening call was made to the victim. This line I am referring because I have been told that my senior friend has referred to the seizure list that the IMEI number was not there in the seizure list. Because IO has obtained that number subsequently. The seizure was made, subsequently those were sent, one requisition was sent to the operator and they have given the CDR as well as the IMEI number. So therefore, the number is not mentioned in the seizure list, Lordship. And he also categorically said that the top portion, Lordship, those documents, the phones were recovered from the possession of Nipin Das, alias Kala, Lordship. And from the evidence of Lordship PWA, that is victim, what I find subject to correction, Lordship, he has stated about identification in two parts, Lordship. First, he said before the incident, he has seen Ahung Wangsa that wearing face mask, and therefore from the body language and as he knows from earlier, he could recognize him. During the incident, he could not identify that it was Ahung Wangsa. Subsequently, after treatment, from the CCTV footage, he confirmed that it was Ahung Wangsa. Keeper, just that already my learned friend has said that page 22, it is already said on the time of incident, I recognized Ahung Wangsa from his wearing apparel and body language, even though his face was covered. So this, and thereafter also, in page 24, he said, during the time of before the incident, the accused came once covering his face, and from his body language, I could not make out that it was Ahung Wangsa. So this part is not contradicted, contradicted by the defense side. They have not challenged that this is a false statement or this is not. He could not identify, Lordship. And subsequently, Lordship, page 25, he said, after my treatment, the CCTV footage was shown to me, and I recognized that it was Ahung Wangsa who threw acid upon me. He said during the time of incident and before the incident, and here he said after my treatment. So three parts are there actually. And the defense side never cross-examined on this aspect, whether there was any CCTV footage, whether it was handed over to police or not. That part has never explained. So whether that was handed over to police or not, they cannot take in the appellate stage, because it is the PWA who can explain about the CCTV footage. When it was not confronted to him, we at this appellate stage cannot give the explanation why CCTV footage was not seized, why it was not placed, because it was not confronted to him.
No, but even if it was not confronted, the fact remains that the CCTV footage was neither seized nor exhibited.
It is
So
true, but
CCTV footage is non-existent for the purpose of this case. It is non-existent. What effect the oral evidence of the IO will have, that is another matter. The IO has said, or this PW8 has said, that I could identify him. And the identification process was complete after he saw a CCTV footage. That is his testimony. That is his oral evidence. If that evidence has not been challenged during cross, that will remain. But whether the footage is there, the CCTV camera is seized, that would be another matter. That would have a corroborating value. That is another matter. But even if the footage is not seized or CCTV is not seized, that doesn't mean the evidence of PW8 goes away unless he is shaken or assailed during cross-examination. That according to us, that is how the whole thing. So was he challenged on that during cross-examination? It has remained unrebutted.
Even there is not a single suggestion that at the relevant time in the traffic point there was CCTV footage. That is not that is my opinion. And another aspect, Lordship. Page 22, Lordships,
Page 22.
page 22, Lordship. Second paragraph.
Yes.
That second row, I was having good relation with Nipen Das. Since my shop was situated on the downside of the market and the shop of Nipen Das was situated at the market, I was having downfall of my business. After a few days, I found one shop at the market nearby the main road and was furnishing the same for shifting my mobile shop. On one day, Nipen Das came to me and asked me not to open mobile shop there. He rather asked me to open grocery shop or any other showroom at the new shop. I did not agree the proposal of Nipen Das. After a few days, Nipen Das again came to my shop and proposed for opening partnership shop with him. I have not accepted his proposal as I was not willing to carry on any partnership business. Thereafter, I have started receiving unknown phone calls and messages threatening me and demanding money from my mobile. On my mobile, I have disclosed the same thing to Nipen Das, but Nipen Das started to avoid me. Earlier, after closing the shop, Nipen Das used to come to my shop, and during that time, Nipen Das has not come to my shop for several days. So this is the motive, because he was also having mobile shop at the adjacent, and he did not want that the victim should open a similar shop adjacent to him, Lordship.
But can it be a motive to kill?
So the motive was to driven him out from that place, Lordship. Because in the
Or not, if not kill, to cause such
grievous injury.
grievous injury.
Grievous injury, to cause grievous injury. And section 326 says that says it is intent to cause grievous injury. Another as well also, another aspect, Lordship, while passing the impugned judgment, the learned Passenger has observed that witnesses in 164 statement said that the Ahu Wangsa is having a cut mark in his cheek, and that was he also he has also seen the said mark, the learned Passenger. Whether that can be relied on, not just I'm placing one judgment of honorable effect court, Lordship. Paragraph 27, Lordship. The appreciation of ocular evidence is a hard task. There is no fixed or straitjacket formula for appreciation of the ocular evidence. The judicially evolved principles for appreciation of ocular evidence in a criminal case can be enumerated as under. Number one, while appreciating the evidence of a witness, the approach must be whether the evidence of the witness read as a whole appears to have a ring of truth. Once that impression is formed, it is undoubtedly necessary for the court to scrutinize the evidence, more particularly keeping in view the deficiencies, drawbacks, and infirmities pointed out in the evidence as a whole, and evaluate them to find out whether it is against the general tenor of the evidence given by the witnesses and whether the earlier evaluation of the evidence is shaken as to render it unworthy of belief. Now, number two, that is important, Lordship. If the court before whom the witness gives evidence had the opportunity to form the opinion about the general tenor of the evidence given by the witness, the appellate court, which had not this benefit, will have to attach due weight to the appreciation of evidence by the trial court, and unless there are reasons weighty and formidable, it would not be proper to reject the evidence on the ground of minor variations or infirmities in the manner of trivial details. The other things your Lordship is very much well aware, and your Lordship has also observed, so I am not going into other principles, Lordship. That paragraph 28 may Lordship may handle.
Yes.
To put it simply, in assessing the value of the evidence of the eyewitness, two principal considerations are whether in the circumstances of the case, it is probable to believe their presence at the scene of occurrence, the PW8's presence is there, or in such situation as would make it possible for them to witness the facts deposed to by them. And secondly, whether there is anything inherently improbable or unreliable in their evidence. In respect of both these considerations, the circumstances either elicited from those witnesses themselves or established by other evidence tending to improbabilize their presence or to discredit the veracity of their statements will have a bearing upon the value which a court would attach to their evidence. Although in cases where the plea of the accused is a mere denial, yet the evidence of the prosecution witnesses has to be examined on its own merit. Where the accused raised a definite plea or puts forward a positive case which is inconsistent with that of prosecution, the nature of such plea or case and the probabilities in respect of it will also have to be taken into account while assessing the value of the prosecution evidence. Here, Lordship, the defense has not shown any reason that why they were falsely implicated by this person, appellants. There is no animosity or nothing on record to show or any suggestion that due to this reason, the witnesses are implicated falsely. For cross-examination part is also, I have already my learned senior panel appellants counsel has read out. There is nothing to show that these witnesses were falsely implicating the appellants. And the one.
Mr. Chaudhary, it will spill over to tomorrow, it looks like.
Yes.
What do you have to say about this observation that the accused was not told that he will not be sent back to police custody even if he fails to confess? That part is definitely not there.
That part has not prejudiced him because, Lordship, what my submission to Lordship is that already there was evidence on record of the judicial magistrate which he clearly stated before the trial court that he has satisfied himself and he has explained everything to him. And to that effect, Lordship, there is order of the learned trial court on the same date when the 164 was recorded. There also the same observation is there that everything has been explained to the accused, and he after satisfying himself about voluntariness and the confession was recorded. To that effect, order is also there in the record, Lordship, on the same day, 8/3/2019. And same thing has been deposed by the judicial magistrate before the court. So there is nothing on record to disbelieve him that he has not explained the consequences or other factors to the appellant, Lordship. And merely but not saying that he will be sent to police or he will not be sent to police custody, they have not got any, they were not prejudiced because, Lordship, as my learned senior friends have already argued that two persons were initially sent for recording 164 statement. They were given 2 days judicial custody. After that, again, they were explained about the consequences. In that manner, the first appellant, that is Nipen Das alias Kala, he resiled from that. His 164 was not recorded. But Ahung Wangsa, he gave his statement voluntarily, and that was recorded.
No, one thing is that he was released from the judicial custody, and there is no application from the prosecution side to take in custody, my lord. So question of my lord sending police custody does not arise until and unless application has been made, my lord.
And regarding Nipen, Lordship, already the IO has said that those phone numbers from where the threatening calls were made, those were recovered from his possession, Lordship. That part is not disputed by the defense. And the other thing, Lordship, the 164 statement clearly said that the conspiracy was hatched by Nipen Kala. And here conviction is under section 120B. It is
Conspiracy cannot be by one person.
that is the 2 persons, Lordship, that both appellants has conspired, Lordship. That they will initially there was a talk that they will kill with Dao, but when Ahung Wangsa refused to kill with Dao, then said okay, then acid was handed over to him to throw upon the victim, Lordship. That part is on 164.
What time this court is supposed to rise today? It's notified. You will be able to conclude in next 3-4 minutes.
This much I have to say.
You have nothing more to say. Then you can reply tomorrow.
Tomorrow.
You have taken note of the.
My lord.
So now let us recapitulate the major or the thrust of arguments from both sides. The arguments from both the appellants are on 3 counts. Firstly, that the prosecution is based on the confessional statement of Ahom Wangsa. But this confessional statement has not been recorded in accordance with the prescription of 164. So therefore, it cannot be relied upon. Second part is that the identification of the main accused, there is some doubt. And that is because the PW8, who is the victim, he has referred to some CCTV footage which he had seen to confirm that this was the accused. But the CCTV footage has not been produced. It's neither been seized or nor has it been produced. The third argument is that the IO has not produced the CDR, and it has not been conclusively proved that the phone call was made from the mobile phone of the appellant.
From to that Anaruddin.
Yes, Naren. These are the basic arguments. And the reply from the other side is to the following effect, that the confessional statement has been recorded in substantive compliance of 164. As he has said, the magistrate has said that he was explained the consequences. Both the accused persons were explained the consequences. After that, one of them backed out. The other continued. So the fact that one of them backed out itself is proof that it was explained to them. Otherwise, there was no reason for Nipen Das to back out. This is one argument. Second, the magistrate in her deposition has mentioned that it was told to them. This is also written, and there is no cross of the magistrate on that. Third is, even if it is said that he was not told that he will not be sent back to police custody, but he says there was no scope for the magistrate to send back to police custody. There was nothing there. So therefore, this question doesn't arise at all. If he was brought from police custody, or if there was an application for police custody, then maybe it would have been material. So, and the third argument is whether the CCTV footage is produced or not. The oral evidence of PW8, which has remained unrebutted, would have a probative value. And he only said what are the steps he took to confirm that the identification was correct. So whether the CCTV was there or not.
That is doubtful.
That
is doubtful because my lord.
But he was not cross-examined on this point.
Because
that's what they're saying.
CCTV was not, that copy was not supplied to me.
No, Mr. Chaudhary, please understand. You
Tomorrow.
respond tomorrow.
Yes.
Even if the CCTV was never there, it's a false statement. Even then, if his evidence was not rebutted, then it will remain on record. It will have a probative value. You address the court on that. That is what we have discussed even in Ashwin Kalita's case by referring to some Supreme Court decision. If a testimony remains unrebutted, then later on it cannot be argued that he has stated falsely. What overall impact the evidence will have is another matter. But CCTV footage is not there.
Yeah.
But he has said how it was, how he identified. That you have accepted during trial. Now you cannot go back on that. Yes. So address the court on that. We are just pointing out what are the issues. And again, there is no prejudice cause, so it's other aspects are satisfied, truthfulness, voluntariness. Then if that is the case, Section 10 and Section 30, which they have not argued, would bring in this conspiracy angle comes in. Because if main accused did not have a personal agenda, he was instigated or brought into the whole thing by the other accused. So that itself brings in the conspiracy angle. If the confessional statement is accepted, then the conspiracy comes in. And if it comes in, then in case of conspiracy, no direct evidence is possible. The court will have to go by the mandate of section 10 and 30. And then the next question would be, you are right, Haricharan Kurmi, it cannot be the sole basis. So what are the other bases? Is it not proved that the incident happened on that day? The place is proved, the time is proved, the other witnesses were injured by spray of some liquid, which shows that it was a venomous substance, which was capable of causing injury. Correct, by whatever name you call it. It was, if not acid, a acid-like substance, which is also recognized under the provision of the IPC. All these 6 persons who went to the doctor, they all had suffered burn injuries. Why would the other persons speak? They had no motive. They were not the targets. The target was, according to prosecution, this person, but others were not even targets. Why would they go to the hospital? And why would the doctor say that they had suffered burn injury? And the evidence of PW10, the doctor, also remains uncontroverted. So why should the court not give evidence weightage to that? And if that is correct, then even without a FSL report, it is evident that the liquid substance which was sprinkled or thrown at them was a hazardous substance which was capable of causing damage to human organ. And then the fact that the deceased suffered this kind of a damage, that cannot be disputed by anyone. His body parts were mutilated, it was burnt. How else does a person get burnt like this? He doesn't get burned if milk is sprayed or alcohol is sprayed. He can get burned like this only if acid is sprayed. What other proof is required? So the standard of proof cannot take the proceeding to a stultifying level that regardless of what the prosecution does, it must be such to raise a genuine doubt that something else might have happened and not what the prosecution is saying. If that happens, acquittal. Otherwise, a little hit here, a little miss there. So you take note of these points and address the court. You have the benefit of one night. We'll rise now.
The medical report was not denied, madam.
Sorry,
Medical report was not denied by the defense.
that's what we mentioned. So, and we'll request both sides to give just a brief synopsis of your points and the decisions which you have relied on what point. That's all. You please put in some effort, huh? Hard so and so list again. Order to get it be listed again tomorrow. Tomorrow, the first item of